Yuvraj? ಅಲ್ಲ ಮೇಲೆ ಮಾಡ್ಕೊಳ್ಳಿ ಸ್ವಲ್ಪ ಮೇಲೆ ಬನ್ನಿ ಅದನ್ನು ಈಗ ಲಾಸ್ಟ್ ಟೈಮ್ ತೋರಿಸಿ ಬನ್ನಿ ನಿಮಗೆ 175 ನಂಬರ್ ಅಲ್ಲಿ
1754 of 2017 between D.N. Ramakrishna, appellant, then Sri Srinivas Ramaswamy and others.
Vishwanath, please mute yourself, sir.
Yes, sir.
Sir, total number 7. Is voice clear, sir?
Yes, yes.
Ram Prasad, sir.
Yes,
Nim
yes,
voice
sir.
ತುಂಬಾ ಮೈಲ್ಡ್ ಆಗಿದೆ ನಿಮ್ದು ವಾಯ್ಸ್.
ತುಂಬಾ ಮೈಲ್ಡ್ ಆಗಿದೆಯಾ?
ಈಗ ಓಕೆ.
Okay, okay, okay. Thank you.
So first submissions will be through VC sir with regard to any adjournments. After VC submissions, any memo submissions from left or right? After memo submissions, any submissions with regard to adjournments from left?
Still first. ಈಗ ಮಾಡಿ ನೀವು ಬಳಿ ಮಾಡಿ.
$2,000 ಪೆನಾಲ್ಟಿ ಕಟ್ಸ್ಬಿಟ್ಟೆ ಮಾಡಿ 3,000 ಕಡ ಪೆನಾಲ್ಟಿ 2,000 ಆಗಿ 20 ಎನ್ಸಿಸ್ ನಂಗೆ ಇಲ್ಲ ಅಂದ್ರೆ ಜಾಸ್ತಿ ಬರೀತಾರೆ. ಏನ್ ಮಾಡ್ತಾರೆ ಕಿವಿ ಬೇರೆ ಕೇಳಿಸಲ್ಲ ಅವ್ರಿಗೂ ಮೈಕ್ ಇರ್ಬೇಕಾಗಿತ್ತು. ಅವ್ರ ಮೈಕ್ ಇಲ್ಲ ಅಲ್ಲೆಲ್ಲ ಬಂದ್ಬಿಟ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಬಂದ್ರೆ ಕೇಳಿಸುತ್ತೆ. 50% ಕೇಳಿಸಲ್ಲ. ಮಿಷಿನ್ ಹಾಕೊಂಡ್ರೆ ಕೇಳಿದೈತೆ. ಹೆಲ್ಮೆಟ್ ತಗೊಂಡಿದ್ದೆ 30,000 ಹೋಯ್ತು. ಆದ್ರೆ ತುಂಬಾ ಬೇಡ ಸರ್ ತೆಗೆದ್ಬಿಡ್ಬೋದು. 14% ತೆಗೆದ್ಬಿಡೋದೇ ತೆಗೆದ್ಬಿಡೋದು ಬೆಟ್ರು. ಆಮೇಲೆ 14% ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ಆಮೇಲೆ ಹಿಂಗೆ ಇಟ್ಬಿಟ್ಟಿದ್ದು 14% being an advocate, you should follow the case. You are not followed. ಎಂಜಿಲ್ ಬೀಳುತ್ತೆ ಮಾತಾಡುವಾಗ ಎಂಜಿಲ್ ಬೀಳುತ್ತೆ. ಮಾತಾಡೋದು ಗೊತ್ತಾಗುತ್ತಾ? ಕೇಳ್ತಿಲ್ಲ. Submission. And
Any mentions through video?
Serial number 1, my lords, I need a week's time, my
Yeah,
lords.
make the mention the matter reaches. Yes.
Please.
Any other mentioning? Any memos
Thank
from
you.
that side?
This matter on an incident based on writing, a lot of that, the matter we posted today. On Wednesday, not posted, we understand there was an officer incident, we can address that issue. Yeah, just won't happen tomorrow, but our time has been completed.
Yes.
Faculty around 14%. I completed the order positive previously. I paid the penalty also. Kindly post it for 76 years age senior citizens. Kindly RFP post it tomorrow. Tapped tomorrow.
697 of 20, my lord. I am appealing for the respondents. Kindly take this for posting, my lord. The matter has been settled and the compromise petition has been filed. That's why the matter needs to be listed.
Yes.
I applied for the respondent 1, 2, 3. Last hearing, the appellant was directed to pay penalty 1,000 rupees. Comply with the office submission.
Lordship, matter has been admitted and trial court records has already been called. 2 IAs are pending, one for staying the proceedings of execution petition and setting aside. May we post it tomorrow, Lordship.
Any mentioning?
Serial number 30, my lords. For the appellants, my lords, play for a week's time, my lords.
The submission of learned counsel for the appellant in view of the non-compliance of office objection. 2/18 stands returned to the applicant. As requested for learned counsel for the appellant, a week's time is granted. Yes.
Much obliged. Serial number 42, lordship.
Yes.
I am after for appellants.
Hmm.
Its time may be granted.
Rejected. Rejected. Yes, next.
Minutes
42 rejected. Next.
serial number 32, my lord.
Yes.
I am for the respondent, my lord. There is no vakalas file ಮಾಡಿದೆ. The senior is not ready, my lord. Kindly I will come to my lord.
The request of the learned counsel for the respondent, a week's time as paid is granted. Yes.
My lord, serial number 38, my lord.
Yes.
A week time may be granted.
Whom you appear for?
Appellant.
The request of the learned counsel for the appellant, a week's time as paid is granted. Yes. For cases.
Orders matter, serial number 1.
I'm for the appellant.
Now,
in this matter.
yes.
For the appellant in this matter, my lords, I request a week's time, my lords, to comply.
For the respondents in this case, my lord.
For the submission of learned counsel for the appellant who is appearing through video conference. Which respondent you are appearing for?
My lords, I appear for respondent number 2, 4, 7 to 9, 11 to 21.
Number 2 to 4, 7 and 9 is also appearing through video conference. Next line, in view of the fact that copy of IA1 bar, copy of IA5 bar 2021 is not covered on the other side. Despite having sufficient opportunities from the date of filing till today, for more than 2 years, the said application stands returned to the applicant. Next line. In spite of granting sufficient opportunity under the order date 29/11/2021 to comply after subjection to IA, objection upon IA. About 2021 to 3/21. 2021, since the appellant till date has not complied with the subjection. Case also stands returned to the applicant. Next slide. 6. The memo has been filed instead of necessary application in accordance with law for the production of the additional documents seeking. This memo along with the alleged documents seeking, which are said to be an USB chip and photograph of stands returned to the party who has filed the said memo. Yes. Next.
Serial number 2, V. Venkatramana or Padmanabha for respondent 1 and 2.
For respondent number 1, 2, 5, and 6. For appellant. Number 4 has not claimed.
Counsel from the counsel for the appellant present. A week's time is granted as finally to take first steps. Correspondent number 4, from whom the notice issue by the registry on 27/2022 has not been returned, nor the acknowledgement has been received. Yes.
Serial number 3, Leeladhar SP.
Yes, sir, withdraw the applications, paper publications earlier filed 2019 and 1/19 and 1/2021 minutes. Permit the appellant to withdraw the said applications minutes.
Which application?
I have filed earlier minutes.
IA number.
IA 1/2019 minutes. Subsequently,
For the appellant present at his submission, IA 1/2019 stands. This disposed of as not pressed. Yes, then.
IA 1/21 minutes.
Hmm.
I filed paper publication subsequently minutes. He's left the address minutes. No respondent.
Take steps once again,
Please,
then you press the application.
please.
Delay. He further submits that since he has taken steps only for 2 times to the unsolved respondent. To take steps once again for unsolved respondent. Accordingly, a week's time is granted to the appellant to take first steps by furnishing the correct, complete and present address of unsolved respondent. Yes.
Serial number 4, Sudha B. KM Timaya for Kevita respondent 1.
For the appellant, my lordship. 1 to withdraw the petition, my lordship. the petition became infractious. My lord.
File a memo, matter would be passed over.
I will file in the register, my lordship.
File it in the court hall, matter would be passed over.
Okay, my lordship. Thank much obliged.
The counsel from both sides present, and counsel for the appellant place for a passover, stating that should file a memo withdrawing the appeal since the appeal has become infectious. Matter stands passed over.
Serial number 5, S. Krishna Swami, DC Deepak.
But, appearance appellant. If the respondent. Right, you know, the elder sister of the appellant. The other two are also sisters. They are already on the card. I think, I'm not going to copy, I'm not going to. But,
Who is dead, who are on record?
first respondent is dead, my lord.
Huh.
If elder dead daughter in the family.
Hmm.
Other respondents are daughters and brother.
Hmm.
And I am also one of the brothers.
Hmm.
So they are, all the elders are on the card.
Hmm.
Therefore, I filed an application, copy was not given to them.
Hmm.
Now I am furnishing them. I claim the property. They are saying that I have been in possession of the
ಏನಿದೆ
property.
ಅದನ್ನು ಜೊತೆಗಿಸ್ಬಿಡಿ ಅಂತ ನೀವು ನಿಂತಲ್ಲಿ ಹೋದ್ರೆ ಅಂತಂದ್ರೆ ಎಲ್ಲ ಬಿಸಾಕ್ತೇನೆ ಅಂತ ಪ್ರತಿ ದಿವಸ ಹೇಳ್ತೇನೆ ನಾನು.
Not married. Responsibility, that should not marry.
Both the application, the affidavit are too brief, bereft of the necessary information. If file a fresh application giving the details, both the application, the affidavit. Yes. In the application, not only you can request the court to take note of the alleged fact that the other respondents are legal heirs, you should also seek the permission of the court to treat them as the legal representatives of the deceased and seeking permission for you to carry out the necessary correction in the cost title. In the affidavit also, except you have only stated that so and so died and so and so she is unmarried and remaining are LRs. You are also required to mention whether they are the class 1 heirs by virtue of what they become the legal representative of the deceased. Yes. There are counsel from both sides present. The legal counsel for the respondent acknowledges the receipt of the copy of IA 1/23. Perused IA 1/23, filed under Order 22, Rule 2 and 4 of CPC. It is observed that the application is bereft for several details for some in some aspect, including small Roman 1. The application doesn't say as to what the applicant wants to do apart from asking this court to take fact of the alleged legal heirship of respondent number 2 to 4. It has not sought for any permission to carry out any amendment in the cost title, treating the existing parties as the legal representatives of deceased respondent number 1 also. So also in the affidavit, except stating that respondent number 1 was not married and died, the opponent has not stated how the remaining respondents become her legal representatives under the family law applicable to them. As such, reserving liberty to the applicant to file the necessary application afresh within 2 weeks from today, IA 1/23 stands disposed of.
Serial number 6, Shivakumar DM.
None appear either physically or through video conference. In view of the fact that the appellant has not evinced and has not taken steps to ensure the service of notice upon respondent for 10.11. By taking first steps by furnishing the correct, complete and their present addresses, the appeal as against respondent number 10 and 11 stands dismissed for not taking steps.
Number 7, Arun BM. Yes, Krishna Swami for respondent.
Appear for respondent. For injunction, mandatory injunction has been decreed.
The counsel for the appellant is not present, counsel for the respondent alone present. Finally, 2 weeks time is granted to file paper.
Serial number 8, Rangaraman V.
For 10 days time, because they are very much residing there. If they are not there, I will take the first steps.
The request of the learned counsel for the appellant. Finally, 10 days time is granted to ascertain the correct, complete and present address of unsolved response number 2, 3 and 4 and to take first steps. 2 weeks time is granted to file paper. In view of the non-compliance of office objections on IA 1 to 3 of 2021, but of granting sufficient, those I stands returned to the applicants. Yes.
Serial number 9, Hanmantappa.
And for the respond number 1 minute.
Time may be granted by filing a paper.
The counsel from both sides, the counsel for the 2 weeks time is paid for is granted to the appellant to file paper. In view of the non-compliance of office objection, IA 1/22 stands returned to the applicant. Yes.
Serial number 10, SS Sudhindra. Raghavendra K for respondent 1.
Waiting for appellant.
The respondent name is not tallying with the column right by the. My original name is, my real name is Nandakumar. As per the KVT also, I have mentioned Nandakumar.
1 minute, please. You find the certified copy of the wakalat executed in the trial. That counsel from both sides present. That counsel for respondent number 3 submits that the correct name of respondent number 3 was N. Nandakumar. However, the appellant has addressed him as Raghu. In order to ascertain whether such a plea was taken in the trial court and what nomenclature the respondent number 3 had filed his wakalat in the trial court. The third respondent is directed to produce the certified copy of the client written statement and the wakalat of the present third respondent in the trial court, who was defendant number 1C, within 10 days from today in the matter.
Cell number 11, HR.
I represent the appellant Miller. I'll take fresh steps, may be granted a week's time. I'll take fresh steps in that.
As prayed for by the counsel for the appellant who is appearing through video conference. The week's time is granted to ascertain the correct, complete and present address of unserved respondent and to take step.
Cell number 12, HR. Ananth Krishnamurthy.
I pray for 3 weeks time to file the paper book. I will also take out notice to the respondent.
Wait for the response.
Counsel from both sides present. As prayed for 3 weeks time is granted to file paper.
Much of that.
Cell number 13, Sridhara K.
Times up.
In the meantime, the appellant to ensure the service of notice upon answered respondents if any.
13, Sridhara K.
1 week times.
The request of the learned counsel for the appellant 2 weeks time is.
14, Chinmay J. Mirchi.
Lendings.
JL Vishwanath.
Respond on this matter. Week time. Take first steps.
The request of the learned counsel for the appellant a week's time is granted to take fresh steps with respect to answered respondent.
15, Ajit Kumar S. Narayan Reddy M. Correspondent.
My lord, I pray for 2 weeks time, my lord.
As requested for by the learned counsel for the appellant who is appearing through video conference, 2 weeks time is granted to file paper.
Much obliged.
Cell number 16, Kishore Kumar.
4 weeks time, file paper.
Two weeks no cost, third week 500, fourth week 1000. 2 weeks. Counsel from both sides present. The request of learned counsel for the appellant, 2 weeks time is granted to file paper.
17, Seshadri NS.
Address furnished in the trial court wherein he was served by lordship is furnished in this appeal also. However, it was concerned with insufficient. Address, my lord. May be permitted to serve on the counsel is appearing for the defendant in the trial court and also take paper publication.
You have to ascertain the correct address now. 12 years back, what address you might have given might have been changed its description now. Bangalore has developed a lot, particularly in that area. So now several crosses, street names, door numbers, etc., might have come. At the request of the learned counsel for the appellant. 2 weeks time is period is granted to ascertain the correct, complete and present address of answer respondent and the text.
Till 18, Manivandan G. Amaresh A. Angadi for respondent.
Request of the appellant, 2 weeks time is granted to file paper.
Till number 19, HN Basuraj, HT Natraj.
And for the
Naik
appellant
for
in this case,
respondent.
my lord, we have filed a NOC wakalat, my lord. And for the appellant in this case, my lord.
Sir, you are not clearly visible, sir.
He is sitting in a vehicle with a backlight. That
No,
is
my
the
lord. I was stuck in the traffic, my lord. So,
vehicle ನಲ್ಲಿ ಕತ್ತಲ್ ಕೂತ್ರೆ ಒಂದ್ ಲೆಕ್ಕ. ಮನೆಯೊಳಗೆ ಇಷ್ಟೊತ್ತಿಗೆ ಕತ್ತಲ್ ಕೂತ್ರೆ ಬೇರೆದೇ ಅರ್ಥ ಕೊಡ್ತದೆ ಅಲ್ವಾ ಹೋಗಿಲ್ರಿ?
no, my lord.
ಕೊಡ್ರಿ. The counsel. Learned previous counsel for the appellant is appearing through video conference. Learned present counsel for the appellant is appearing physically. Yes, vice versa. Hearing their submission. The learned counsel Sri H.N. Basuraju is permitted to retire from appearing for the appellant in this matter, since the appellant has engaged the services of the present counsel. Yes.
Till number 20, Shanti Bhushan H. Somshekara KM. Correspondence.
As requested for by learned counsel for the appellant, 3 weeks time is allotted.
Still number 21, Ganapati Shastri.
Yeah, 2 weeks.
22, DC Deepak.
I appear on behalf of appellants members.
Yes.
Plus a week's time may be granted, we'll take fresh steps to add 3 members.
For the appellant, prays for a week's time to take fresh steps. Or notice upon unserved respondent number 3. A week's time as prayed is granted.
23, Nagesh BS.
I appear for the appellant, my lords. My lords.
Same order.
Yes.
Yes.
Great.
Till number 24.
Appear for the client either physically or video conference. The perusal of the offer sheet will go to show that the present appeal is of the year 2018. which the office subsections appears to have not been complied till January 2023. As it just to comply the office subsection, it appears the appellant has taken about 5 years time, nearly 5 years time. Thereafter, the matter came to be admitted on 13/2/2020. However, till date, the appellant has not taken steps to issue notice to the respondent. In the above background, when the appellant is not evincing any interest to prosecute the matter and not even has taken the step further, counsel for the appellant also has not even appeared in this matter, either physically or through video conference. Inference can be drawn that the appellant is not interested in prosecuting the matter and to take steps. Hence, the appeal stands dismissed for non-prosecution as well as for not taking step. Yes.
Seal number 25, Sunita H. Singh,
Please, your lordship.
Krishnamurthy MR for respondent.
Your lordship, these applications, I have one file to bring the legal heirs of respondents, sole respondents on record, please, your lordship. On account of which I'm not able to serve the copy. If your lordship may be pleased to order notice to the said LRs, please, your lordship.
For the submission of the counsel for the applicants in a 1 of 21 to 3 of 21. I do not find any reason for non-compliance of office objection of serving the copy of the said IA to the other side who is being now represented by his counsel. As the question of ordering the notice cannot be agreed unless the copy is served on the other side.
Your lordship,
Hence, the application
please, your lordship. Sole respondent.
21 stands written to the applicants. Yes.
Seal number 26, D. Prabhakar. Subhash Shastri, respondent.
Yes, Lord. The Lordship may kindly see that on earlier date of hearing, I filed a memo stating that the second respondent has demised and your Lordships have directed me to file the death certificate. In spite of my best efforts, I could not secure the death certificate. I have filed an affidavit to that extent along with a memo stating that she married my father after my mother's demise, second marriage. She did not even stay 15 days. We were not aware of her whereabouts. And the respondents who are the petitioners before the FTP court, before the trial court, have also filed a memo. They have also not indicated the date of death. Hence, I could not secure anything, death certificate, my lord. I have produced the certified copy of the memo filed by the respondents before the court below. And it is undisputed fact that she is no more.
Have been furnished with a copy of this affidavit. You appear for
Respondent 1A, B and C.
proposal for the appellant. Proposal for respondent for 1A, 1B and 1C are physically present. The responsible for the respondent 1A, 1B and 1C submits or acknowledges the receipt of the copy of the affidavit. Dated 21/17/2023, filed by the appellant number 1. The respondent to file their objection if any to the said affidavit, 2 weeks time is granted.
But sir, IA number 7
Yes.
does not arise for consideration because that order which was
Okay.
passed has lapsed and a new order was passed. So IA number 7 for vacating the interim order does not arise.
They have filed an application for IA extension of interim order.
Both applications.
If that extension of interim order also does not survive,
Yes.
that is also dismissed as infructuous. This may also be dismissed as infructuous. That application is not put up today. In fact,
No, it is there in the file.
when the interim order was granted by this honorable court, none of the respondents were alive, and it was only for a certain period, only for a limited period until 30th. Thereafter, the matter got listed before your lordship almost for 4 times, and it is not extended.
Let that IA be placed by the registry, then we consider this.
My lord, the matter has to be now posted for admission, my lords. The matter requires admission now. The matter has not been.
ಈಗ ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದೇನೆ ಅಲ್ವೇ? ನಿಮಗ್ ಬೇಕಾದಂತ ಹರ್ರಿ ಯಾಕೆ ಮಾಡ್ತೀರಿ ನೀವು?
At least a week's time. Within a week's.
Serial number 27, R.A. Devanand.
An appearance the matter could not be proceeded today, which the matter will be talked next.
Hearing on interlocutory application, serial number 28. Dr. Nandakishore.
Hearing for appellant, my lords. IA number 1, delay continuation, 1 day delay. And it was directed to serve hand summons for the respondent number 2. It has been duly served. Affidavit has been filed.
On which day you were permitted to take hand summons?
In August minutes, 2018 August. Six, 8, 2018.
The affidavit speaks about service of grant summons upon the learned counsel for respondent number 1 only.
Sir. The fourth paragraph we have mentioned, respondent number 2 has been duly served. Dated 8/8/2018. They mentioned it in the affidavit.
So despite the respondent number 2 being served, you are directed to take hand summons to their learned counsel also.
My lords, we have given it. Respondent number 1 and 2, same counsel appearing in FDP.
That you have not stated in your affidavit.
We have stated, my lords, fifth paragraph. It is humbly submitted. Counsel for the respondents 1 and 2 are the same, been duly served.
You have not stated that the same counsel was appearing for both the respondents.
My lords, it's stated, my lords. Fifth
Where you
paragraph.
have stated
In fifth paragraph of the affidavit, my lords.
what it states.
It is humbly submitted that since the counsel for the respondent number 1 and 2 in FDP so and so has been duly served.
Yes.
Yes,
You have stated the counsel appearing for respondent number 1 and 2 have been duly served.
yes.
In your submission in para 3, you have shown that the counsel was served, but you have not stated that the same counsel was appearing for both the respondent. When para 3, 4 and 5 read together, it gives an impression that we have served upon that particular counsel who was appearing for respondent number 1. That is what the observation of registry also. The affidavit gives an impression the compliance affidavit is with respect to counsel for respondent number 1. One sentence you could have added in your affidavit, which you have not done.
Sorry. Sorry.
For the submission of learned counsel for the appellant on the affidavit dated 10/8/2018 filed by the first appellant regarding complaints of the direction dated 6/8/2018 as observed by the registry. The said complaints affidavit shows that the complaints has of serving the appeal papers to the learned counsels for the respondents in FDP 7/2018 has been complied only with respect to respondent number, only with respect to the learned counsel for respondent number 1. Though the learned counsel for the appellant submits that both respondents in FDP proceedings were being represented by the same counsel, however, the same cannot be inferred by a reading of the affidavit under consideration in its entirety. As such, the appellant is granted 2 weeks time to do needful in the matter.
Interim order may be kindly extended.
29, Ken Putegoda, case Sanat Kumar Shetty for Kevata respondent 1.
Respondent number 1 was a decision matter. I take necessary steps. Kindly shut up.
The counsel for the appellant alone present and prays for short accommodation to bring legal representatives of. This is the respondent number 1 on the next. Admittedly, the condition of death of respondent number 1 was placed on record as long back as on 14/2/2023. A certificate of death also, a copy of certificate of death also has been filed along with the memo reporting the death of respondent number 1. As such, by virtue of operation of the statute, the appeal as against respondent number 1 stands abated. Yes.
Serial number 30, sorry, serial number 30 urgent. Serial number 31, RB Sadashivappa, Sidmalappa PM, correspondent.
The requirement legal appeal will be raised from the model. We decide to have the further also to decide. ಹಳೆ ವಕೀಲರು ಇಲ್ಲ ಹೊಸ ವಕೀಲರು ಇಲ್ಲ.
Serial number 31, RB Sadashivappa.
For the appellant, Vinod, please. I have already complained the presentations, please. I complained it on 41/7.
The counsel from both sides present physically. Though the learned counsel for the appellant submits the is subject by virtue of the order dated 24/7/2020. The subjection have been complied with. There is no endorsement to that effect by the registry in the proceeding sheet. As a registry to verify and submit whether office objections are complied. That is possible.
Serial number 33, HS Santosh T. Mohandas Shetty, correspondent. Admission matters.
My lord, I am appearing on behalf of the appellant, my lord. In this case, this is a eviction suit, my lord. So I pray for a week's time, my lord. I have instructed my client to talk to the owner and take some time to vacate the premises, my lord.
The counsel from both sides present, the learned counsel for the appellant prays for time which is not opposed by the learned counsel for the respondent. Hence, the matter could not be proceeded with.
Serial number 34, Sidmalappa PM.
Appellant lordship. For partition is decreed. I am the first defendant.
What is the error in the improved judgment?
Yes, lordship. The father filed the appeal before the Honorable Court challenging the judgment and decree. The self-acquired property of the father, he has purchased the property That property also it is granted decree to the son. That was challenged by the father.
Which is that property? The counsel from both sides present. That's paid for by Learned Counsel for the appellant. Yes.
Lord, the final decree is wrong. Same is challenged by the appellant here. In RFA number 1922 of 22, my lord, it may be connected along with subpoena, my lord.
It's for 2 weeks time. It's also submitted from both sides that arising out of the final decree proceeding. The very same original suit, RFA number so and so is pending and placed to list both the appeals. Registry to verify and do need.
Number 35 as Ramurthy. Number 35 as Ramurthy.
Appears hence the matter could not be proceeded.
Number 36 Matthew PM.
Here in this case, as per the sale deed in page number 49, there is a common area of 16 feet by 7.2 feet, which has been shared for passage only between two neighboring houses. Now the lower court has passed an order saying that common passage except 7 feet 6 inches by 3 feet 2 inches. Here in this order, the lower court says that that belongs to the defendant, which has been challenged before your lordship. Sale deed has been made in the year 1974.
Giving what reason the staircase area was exempted?
Because the sale deed very clearly says that it's a common area. In page number 49 may be looked into your lordship. The open space on southeast side marked as segment number 6 is common and should be used as a passage only by this purchaser and Srimati Anisha A. No construction should be put up by the purchaser and the owner of S area in this segment number 6.
Is it your case that in that common passage area the staircase was put?
No, there is no staircase even today. Even till date, nothing is there.
Then the impugned order, how do it says that except area of 7 feet 6 inches into 3 feet 2 staircase area?
That's what, because in the sale deed given by Anisha, she just makes a hint saying that a portion plan with a common right to put any staircase. She, even though she doesn't have any rights in the common area, she conveys this right to her subsequent buyer in 2004. This sale deed was made in 1973. In page number 60 may be looked into. 49 and 60 will give a clarity, Your Lordship. In page number 49 says,
I don't have in page number 49 except 42, which is the Wakala.
The additional documents, Lordship. Additional documents was filed. The sale deed page number 6 of the first document, Lordship. Oh, sorry, Lordship. Additional documents.
Additional document ಅಂತ 5 ಸರ್ತಿ ಹೇಳ್ತಿದ್ದಾರೆ. ನೀವು ಬೇರೆದೇ ಲೋಕದಲ್ಲಿ ಇದ್ದೀರಿ.
Copy of the sale deed, sir.
Page number 6 of the sale deed dated 3/5/1974. Schedule of the property. The fifth line from the last version.
1 minute.
The 3/5/1974.
This is sale deed is between whom?
It is between my grandmother and my neighbor.
Your grandmother was vendor or purchaser?
Purchaser. One Mr. Arugya is the vendor.
Rita is your grandmother.
Yes, Russia.
What is the measurement of the open space shown in the schedule in the sale deed?
16 by 7.5.
How to infer that? The said schedule doesn't speak about the
16
measurement of the open space. Admit notice PCR. Paper book 6. Yes, next.
I1 IA is there, sir. To stay the person. Stay.
Let them come. Yes.
Serial number 37, Prashant.
What is the second wife of? Request of the proxy counsel for the appellant. Matter is possible. Yes.
Number 39. G.R. Lakshmipati Reddy.
Shall I continue?
For any invited, serial number 40, N. Swami.
Not yet possible.
41, Nitish Sri.
Taking for respondent number 3, my lord. And you pass over the matter, my lord. But there's a recent judgment of this honorable court which deals with done with food Kharab land, especially B Kharab land, which is the question before my lordships. If my lordship permits, I'll place the judgment. Just give a copy to the other side. Para 78 onwards. As also para 21. Page 13, para 20. Take my lords to para 78, my lord.
1 minute.
Yes, ma'am.
respect. Making Shloka versus manager. The judgment. The deeds. Rights of title holder of a land. Would correct. Even though the said good crop is not asset and revenue, and he is not paying revenue upon it. It is held that long he continues to be a title holder. That property, even if it is a good curve, not accessible for payment of the tax, public revenue, still he continues to be of the same would continue, even if it is a portion of the curve used by public. Maybe as a for passage, maybe as a footpath, etc. However, in second place, land is not assessed for land revenue. He is entitled for possession when once the said land is acquired. However, once the said land is acquired, the entire ownership of the land goes to the acquiring authority. It also extinguishes the rights of the public to those, even though those publics were using that portion of that till then. The extent. So, what woman want? Whether AWHO was the owner of that portion of the land, the owner obliged to take hold of a portion of the land in dispute as a temple premises. Even if it is established that AWHO is the title holders, public owner of the said piece of land, this is the dispute is not with respect to the ownership of the land alone, also the management and administration of temple. Undisputedly is a public place of worship. After alleged acquisition, the surrounding land. This also doesn't give the correct answer.
I'll answer my lord's question. I'll answer my lord's question.
First, see, how do you establish that you are the title holder of that particular?
The entire survey number was handed over to AWHO. That is my predecessor in interest. Now, since, in fact, in this judgment itself at para 21, it says, when a survey number, if a survey number belonged to a person
that part of the land which is classified as Potkara would also be included in his ownership. So it is not in dispute that the entire survey number was transferred to AWHO. In fact, the RTCs that I taken, my lords, at an earlier point in time clearly states that including the Potkara was in AWHO's name. By virtue of that, since the entire survey number.
Once again, draw my attention to that particular portion of the allotment of that area to you.
Yes, my lord. My lords, look at exhibit D1, my lord.
Exhibit D1.
D1. My lords have exhibit D1, my lord.
Once again.
Yes, ma'am. Lords looks at the award.
What is a document, please?
This is the acquisition award. This is the award pursuant to the final acquisition notice. This is produced by the defendant themselves, where with respect to where this temple is situated, that is survey number 25, there was 5 acres, 36 guntas that was acquired for AWHO. That, my lords, will find under award, says under section 11 of the Land Acquisition Act of 1894. May I point out from the original, my lord?
Please. Major problem is with the paucity of time and several adjournments. I have to refresh the memory.
Point out
You have paid the land value of this portion also to the government?
Yes,
That
madam.
is 700 rupees what you contain?
Yes, madam. I have. That is the 575 rupees. In fact, that,
575.
yes, madam. The portion that I have just pointed out from Exhibit D1, award, it says, madam, under Section 11 of the Land Acquisition Act 1 of 1894, whereas an extent of land in survey number 25 measuring 5 acre 36 hectares of dry land situated in the village of so and so in the Bangalore South Taluk in the registration district of Bangalore, and registration the name of or occupied by the person specified below has been declared by government at pages so and so of Karnataka Gazette on so and so on due consideration of the various circumstances connected with the acquisition as here before set forth makes the following award under my hand. True area of land is 5 acres 36 guntas. Compensation allowed for the land is at rupees 28,000 per acre of dry land for 5 acres 25 guntas, SA at 15%. Then value of 0.10 guntas of unreserved kharab at rupees 20,000 per acre, 5,750. Then, my lord, value of 0.01 guntas of reserved kharab land at rupees 20,000 per acre, which is 575 rupees. Now, this is the portion that has been assessed. And if I could trouble my lords, to 2 pages after where my lords had just perused. About 2 pages after that, my lord, where it says a sum of rupees 575.
Yes.
My lords have it?
Yes.
Obliged, my lord. A sum of rupees 575 being the value of 0.01 guntas of reserved kharab land may be sent to the Tashildar, Bangalore North Taluk. In the same page, my lord, at paragraph, at serial number 5, compensation amount of reserved kharab measuring 0.01 guntas of rupees 575 to be sent to Tashildar, Bangalore North Taluk. Then, my lord, if I could trouble my lords to go to the last portion where the order is there, just before there is that scratched out thing, where it says award is approved for rupees 1,87,450 with the direction that the compensation amount of rupees 1,86,875 shall be deposited in the appropriate civil court under section 30 and 31(2) of the Land Acquisition Act for adjudication, and rupees 575 being the compensation payable towards the reserved kharab land be sent to the Tashildar, Bangalore North Taluk. This bifurcation is crucial, my lord, because the majority of the amount is paid to the landowners. Only with regard to the reserved kharab land, 575, it is said it will go to the Tashildar. This clearly establishes
Document evidencing that you have paid this 575 rupees.
My lord,
The other day you drew my attention, some document.
Not that I submitted that I will make it available, my lord. I will make it available. It hasn't been produced in the lower court or before this honorable court. It is not in dispute. They haven't raised a contention, but of course it is my duty to satisfy my lord's questions.
There's no document to show that you have paid this 575.
It has been paid, my lord. I will produce the document. I will make it available before the honorable court. For whatever reason, it was not produced before the trial court below, but I will make sure that this document is produced before the honorable court. So this doubt is also cleared. It is not their contention that we have not paid that 575. With due respect, my lord, it is their contention, since it is reserved for public use in that same order, my lord. in that same award, D1, there is this portion where it says it's reserved for public use. Structures anta ide, where it says Muniswami Temple, Stone Mandap, these buildings are left for public use. They are not valued and the compensation is not determined anta. So they're harping on this portion to say, since compensation is not determined, since it is left for public use, you're not the owner. Public continues to be the owner, which is why, my lord, I would say the recent judgment that I've placed before my lordship clearly states that anything under that survey number will be given to the person for whom it is acquired. There is not a single shred of paper which says that everything in that survey number except this stone mandap is not owned by AWHO. And as a judgment discusses, my lord, this not assessing it is only because the owner cannot cultivate it or the owner cannot put it to use. It's unairable. That is the only reason why it is not assessed. And that judgment also goes on to say at paragraph 90, 95, my lord, 95. Thus, as a result of this discussion, it is clear that every land which is measured and classified as a survey number, title of the said survey number would always vest with the individual and no portion of it would be transferred in favor of the state merely because that portion has been classified as unairable. The mere fact that portion of an individual's land is reserved for public purpose or that the public in general are utilizing the land will also not divest the individual of his title over that portion of the land. This is squarely applicable, my lord, in my humble submission to the facts of the instant case. I am the owner of the entire survey number. While there may be a part of that, a small part of it that is reserved for public use, but that does not divest my title over that portion. And in the same judgment, my lord, there is the example of an easementary passage that is given, where again, I will not cease to be owner of that easementary passage, while I may be obligated to let the public use it. And it has always been my contention that I'm always letting the public use the temple. So question of management, with due respect, my lord, of the temple also will not arise, because the defendant has no right whatsoever to claim exclusive management of the temple when I am the owner of that land on which the temple is situated.
Since last several hearings,
Yes,
both of you are canvassing something. Rather than going to the most important intrinsic point involved in the matter, beating around the bush exercise being done. Assuming for a moment that say that property is situated amidst your property, you have not denied anyone from entering the temple or worshipping the god, etc. But the problem is regarding the management of that temple, which is a public purpose, meant for public purpose. Even by virtue of this judgment, which are no relying, assuming for a moment that you continue to be the owner of the land, but you cannot deny that it is for public purpose. A temple is there. You have not denied. You have not denied. Rather, you have made it very clear that you will allow not just residents of the housing society, even the outside devotees also to come and worship.
Yes, ma'am.
That is your submission. But the thing is, the management of that temple. Your last statement now made that you being the owner of the land, it is your property or you can manage the temple. That has to be substantiated and justified, not by a mere statement, by virtue of law. Maybe when a temple or a place of public worship is located in a private land, let us now take it as a private land because you would say that you are the title holder of that bit of land, 1 gunta. Then, if a public place of worship, a temple is situated on a private land, what are the laws that are applicable to that? Regarding its management, administration, etc. That aspect I have been repeatedly asking you since several days of hearing, but neither of you, particularly you, since say you are continuing an argument, they are yet to begin their argument.
In fact, it's posted for their arguments today.
for their argument. And these questions were posed, a common question for both sides. Both sides were asked to assist the court on this point. So assuming for a moment, they deny that you are the owner. We will hear from them also. Now, after considering your submission hitherto, which was the repetition of the previous occasion also, even if it is taken that the entire land in survey number 25, including this 1 gunta of land, was delivered to you and you have paid the land value to the Tahsildar by virtue of exhibit D1 and another document, which you say that you would place the same before the court, and you also submit that the same is not in dispute. Assuming for a moment that you have paid that land value of 500 rupees plus 75, 575, you have become the owner of that 1 gunta of land also. But admittedly, there is a temple, public place of worship on that. Your suit is that the defendants are trying to interfere in the temple affair. They say the temple is in a dilapidated condition. We are the devotees. We want to improve the temple. Probably in their written statement, they have not said that they are the owners of the temple. Probably.
They have
Subject to what you
They have
submit and
not.
what they submit. They have not claimed their ownership over the temple. They say, we are developing that temple, we are constituting or we have constituted a committee or a trust for that temple, we are developing that temple. You say that there is a trust to take care of the temple constituted by the residents in the society. They would do it. I asked both of you to come up with the law which governs this aspect, a public place of worship in a private land.
May I make my submissions, my lord?
Please.
My lord, if I could trouble my lords to look at my prayer in the plaint, what have I asked?
Take it.
Before the plaintiffs here and most respectfully pray that this honorable court will kindly be pleased to pass judgment and decree in their favor and against the defendant. For permanent injunction, restraining the defendant, their member, agents, servants, henchmen, and any other person claiming under them from interfering with the plaintiff's peaceful possession and enjoyment of the suit scheduled property in any manner whatsoever. With due respect, my lord, there is no question of management or otherwise who has to consider managing the temple, etc. From the time AWHO came into possession, there is always a resident.
Then, fine. If in fact say I was under the impression that you have expanded the prayer and shown the inclination of allowing them to worship, then if according to you, admitted it's a public place of worship, then how can you prevent anybody from entering there? How you are entitled for this relief at all?
My lord, may I submit?
So then there is no need to look into the other face of it, how to manage a public place of worship when your prayer doesn't warrant it.
I am asking for this prayer based on the submission that I am the owner of the property. When I am the owner of the property, my possession cannot be interfered with. That does not mean that public cannot use it. If my lords is so inclined, may kindly submit, my lord.
How are you telling that they are interfering in your possession? When it is a public place of worship, how can you claim the exclusive possession?
My lord, I have.
It's a public place of worship.
I have stated, I have produced documents with my claim. I will take my lords to each of those documents where specifically stated incidents where they've come in, they've tried to put another hundi, they've come in, they've tried to take over the reconstruction of the property.
This is
of the
counsel.
temple.
If I come to your way of, or say your point of argument, we switch over to other. If I switch over to your other portion, then you come over here. Come over here. Your prayer is very, very limited. Scope is very limited.
Only to the dependents, my lord. At no point in time have I said that I will not be preventing members of the public from offering public worship. I have only requested the court to restrain the dependents from disturbing my possession when they come into the property.
Merely using the word repeatedly, interfering your possession won't strengthen your case unless you show that, unless you satisfy the court that what that possession means in the instant case.
You yourself has shown that particular judgment, a recent judgment of this court. This clearly go to show that he continues to be the owner, a title holder. He continues to be the title holder, but the users of that particular property won't say lose their right to use it.
I'm not preventing their use, my lord. I'm preventing their attempt to usurp the temple property by, I have produced documents where I have stated, they have written letters themselves saying, ನಮ್ಗೆ ಇಷ್ಟು ಜಾಗ ಕೊಡಿ, ನಾನು ಇಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತೀನಿ, ದೇವ್ರು ಇಲ್ಲಿವರೆಗೂ ಆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗೋವರೆಗೂ ಹೊರಗಡೆ ಇರ್ಲಿ, ಅದಾದ್ಮೇಲೆ ನಾವು ಇಲ್ಲಿ ಬರ್ತೀವಿ, ನಾವು ಇದ್ ಮಾಡ್ತೀವಿ, ನಾವು ಹುಂಡಿ ಹಾಕ್ತೀವಿ. They have said all that. Now, if that isn't interference with possession, my lords, I fail to understand what is.
Possession ಅನ್ನೋದನ್ನು ನೀವು first define ಮಾಡಿ. You cannot equate this possession with possession of your rest of the property. Possession, when a particular piece of land, though alleged to have been acquired and given to you, number one, no compensation is paid to the land loser.
Yes, my lord.
Leave that apart. These are not the land owners, original land owners. Leave that point for the time being outside the purview of this suit. Secondly, admittedly, that particular portion of the land bears a temple of public worship. A temple of public worship. Though you continue to be the owner of the land, you are not the owner of the temple.
No, my lord, I beg to differ, my lord. I beg to differ, my lord. I am the owner of the temple by virtue of this judgment as well. It says public use is permitted. Does not mean I'm not the owner of the temple. Could I take my lords to the recent judgment?
1 second, 1 second. Where is the valuation with respect to that particular temple is made, and which is the order that shows that
575, my lord, rupees 575 that I have paid.
document that shows that the land with the temple has been delivered to you under the acquisition?
My lord,
No document.
the entire, with due respect, my lord, may I ask myself the other question? Where is the document which says that land with temple is not handed over to me? The entire survey number has been handed over to me, including all structures, unless there is a specific order which says that in this whole survey number, but for 0.01 guntas, everything else is handed over to you. It is to be taken, especially in light of all the judgment that I've placed even on earlier occasions.
The entire survey number 25, including the temple, has been handed over to you.
My lord,
when you assert your title, the burden is upon you.
Yes, my lord.
You cannot, putting the negative aspect, you cannot say, show
Yes,
me
my
the
lord.
documents that the
It is my contention.
not delivered.
Yes, my lord. Exhibit D1 clearly establishes
Ah.
that the entire extent of survey number 25 has been handed over to me. The part by part assessment in terms of what is reserved kharab land, what is unreserved kharab land, what is the remaining land. Each of this has been assessed and each of this has been handed over to me. The composite survey number 25 has been handed over to me.
Can show me that entire survey number 25, each part of it, including all structures, have been handed over to you. I will underline it.
Yes, my lord. My lord, the award portion that I pulled out.
Now, whichever document, I do not know
Exhibit
which
D1, my
document,
lord. Exhibit
whichever
D1, my lord.
document, whichever paragraph.
Exhibit D1, my lord.
Exhibit D1 I have.
Yes, my lord. My lords have exhibit D1, that portion that my lords have just gone through with the orange post-it, my lord, the orange post-it at exhibit D1.
Whether in your plaint you have stated that the entire area and survey number 25 has been acquired and handed over to you?
My lord, in my plaint, I have
Your
stated
plaint.
that the entire property, which is also inclusive of 25, is handed over to me, and I am AWHO has handed it over to me. If my lords look at paragraph 3 of my plaint.
Yes.
In furtherance of their objectives, EWHO approached BDA for allotment of land in Bangalore City for construction of flats, etc. Upon request of EWHO, BDA have allotted lands survey number 24/2, 25, 34/1, etc. So total extent of 14 acres, 22 guntas, which also includes survey number 25, has been handed over to me.
Yes.
It is my express contention that I am
Your
also.
contention is that the lands in these survey numbers have been handed over
Yes,
to
ma'am.
you.
Yes,
It
ma'am.
does not mean the entire land in all these survey numbers have been handed over to you.
It does, my lord. With due respect, my lord, it is my contention that the entire boundaries, in fact, my lords had looked at the other possession certificate also, where we had discussed about how the boundaries of each survey number is not mentioned. Composite survey number so and so has been handed over. My lords also was pleased to look into it. Possession certificate, which is also marked.
Whether the reading of the plaint upon request AWHO BDA have allotted lands in survey number so and so, so and so, so and so. Does it mean that the entire land in all these survey numbers?
Yes, madam.
How? You have not used the word the entire land bearing survey number. You have only stated lands in survey number.
My lord, I'll leave it to my lords. This is the general interpretation. I've tried my best to assist this honorable court. When I say responsibly that the lands in survey number so and so, it is my humble submission that this honorable court take that into consideration, especially when I've said measuring an extent of 14 acres, 22 guntas. There is not a single gunta of land outside of this 14 acres, 22 guntas that is outside of these survey numbers, my lord. This has been.
No, these statements repeatedly you have been making. Where is the pleading or the evidence in that regard? Maybe true, I'm not stating that say what you are telling is not acceptable, but the thing is, where is the proof? Basic thing is that
the sale deed, my lord.
There must be a pleading.
Yes, madam.
When you say the entire land in survey number 25 was handed over to me along with other survey number, primarily there must be a pleading to that effect.
Yes, madam.
A reading of according to you, the pleading is para 3.
And para 4, my lord. Could I take my lords to para 4 also?
Yes.
Thus, AWHO became the absolute owner, lawfully seized and possessed of the above lands by forming plots for construction of so and so, so and so.
Yes. So, a reading of para 3 and para 4 does not say or does not show that these survey numbers in total had 14 acre, 22 guntas, and all that 14 acre, 22 guntas was handed over to you. That was one way of telling. You could have said these survey numbers which runs into 6 or 7 survey numbers in total, maybe not individually, at least the most shortest simple way, the minimum requirement in total was measuring 14 acres, 22 guntas. And that entire 14 acres, 22 guntas of these survey numbers were acquired and delivered to me. In such a case, fine, the pleading can be understood, subject to what the other party says, that according to pleading, these survey numbers put together was measuring or with an area of only this much, 14 acres, 22 guntas. And they have stated that the entire 14 acres, 22 guntas in these survey numbers have been handed over. Therefore, nothing is left in any of these survey numbers. But you have stated lands in survey number so and so were acquired or handed over to you.
My lord, may I interrupt? Is my lord's question that the lands do not mention structures? Is that my lord's question, my lord? That the lands, the pleadings here do not mention lands along with structures. Is that my lord's?
Who said repeatedly, vehemently that rather than, if the court can say, rather than in a submission manner, but in a fighting spirit, you said that the entire land in survey number 25 was acquired,
yes,
not even sparing even a single bit of land. The entire land in survey number was handed over to me.
Yes, ma'am.
That made this court to ask you to show that the entire land in survey number 25, where the temple is said to have been situated, was acquired and delivered to you.
Yes, madam.
Then you drew the attention of this court to para 3. By reading this para 3, it doesn't give a simple bare reading impression that the survey number mentioned in para 3, which are 6 or 7 survey numbers, were acquired in their entirety. Nor do they give the extent of the land in each of the survey number, how much is acquired and how much is given to you. It only says, our godown in Alidda, ಅಕ್ಕಿ ಮೂಟೆಗಳನ್ನು ನಮಗೆ ನೀಡಲಾಗಿ 150 ಅಕ್ಕಿ ಮೂಟೆಗಳನ್ನು ನಮಗೆ ಕೊಡಲ್ಪಟ್ಟಿತು. It does not mean that Godon bears only 150 rice bags.
Yes, ma'am. I get my lord's question, which is where I'll also rely on the exhibits are produced. Sale deed ಮತ್ತೆ possession certificate. ಎರಡರಲ್ಲೂ it said all that piece and parcel of land in survey number so and so, so and so, so and so ಅಂತ ಇದೆ. If I could take my lords to the sale deeds. The sale deed executed by BDA in favor of AWHO. Exhibit P2, page number 150, the original one. Exhibit P2.
Exhibit P2. ವಿಷ್ಣುವಾಗಿ ನಾವು ರೂಟ್ ಕ್ವಶನ್ ಇನ್ನೂ ಹೋಗ್ತಾ ಇಲ್ಲ.
Yes, madam.
ಇನ್ನೊಮ್ಮೆ ನೆನಪಿಗೆ ತರ್ತೇನೆ. ಈಗ ನಿಮ್ಮ ಪ್ರೇಯರ್ ಓದಿದಾಗ ನಿಮ್ಮ ಪ್ರೇಯರ್ ಎಷ್ಟು ಕನ್ಫೈನ್ ಆಗಿದೆ, ಎಷ್ಟು ಲಿಮಿಟೆಡ್ ಆಗಿದೆ, ಆ ಏರಿಯಾ ನಾವಿನ್ನು ಟಚ್ ಮಾಡ್ತಿಲ್ಲ. ನಾವಿನ್ನು ಸುತ್ತಮುತ್ತ ಕಾಂಪೌಂಡ್ ಒಳಗೆ ಓಡಾಡ್ತಿದ್ದೇವೆ. ನೇರ ಬಂದು ಟೇಬಲ್ ನಲ್ಲಿ ಡೈನಿಂಗ್ ಟೇಬಲ್ ಎದುರು ಕೂತು ವಾಟ್ ಈಸ್ ದ ಮೆನು ಅನ್ನೋದು ಇನ್ನೂ ನೋಡ್ಲಿಲ್ಲ.
Yes, madam. I could trouble my lords to look at the schedule.
No, exhibit P2 is what document?
This is the sale deed executed by BDA in favor of AWHO for the entire survey numbers.
Most problem is that you produce only the copy or certified copies of these documents without any typed copy of the same.
Paper book alide so typed copies in the paper book. Page 152 exhibit P2 typed copy ಇದೆ. The relevant portion is at page 163.
ಇದರಲ್ಲಿ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಯಾವುದು?
One all that piece and parcel of land in survey number 24/2, 25, 34/1, etc., etc., possessing 14 acres, 22 guntas and founded.
Fine. It says all that piece and parcel of the land, but it doesn't say all the land in its entirety in survey number so and so.
My lord, with due respect, my lord, this is
the common practice of.
Yes, my lord.
All that piece and parcel, all that land, all that property bearing number so and so.
Yes, ma'am.
It doesn't mean the entire land in these survey numbers. All that ಅನ್ನೋದನ್ನ ನೀವು ಎಂಟೈರಿಟಿ ಅಂತ ರೀಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. All that land ಅಂತ ಹಾಕೋದಾದ್ರೆ ಅವರು ಮೆಜರ್ಮೆಂಟ್ ಬೌಂಡ್ರಿ ಕೊಡುವ ಅವಶ್ಯಕತೆನೂ ಇರಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 25 ಪೂರ್ತಿ ಭೂಮಿ ಕೊಟ್ಟುಬಿಟ್ಟಿದ್ದೇನೆ. ಎಷ್ಟೋ ಸಮಯದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 25 10 ಎಕರೆ ಇರ್ತದೆ, 3 ಎಕರೆ ನಿಮಗೆ ಸೇಲ್ ಮಾಡ್ತಾರೆ. ಆ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿಯೂ ಕೂಡ ಆಲ್ ದಟ್ ಪೀಸ್ ಅಂಡ್ ಪಾರ್ಸಲ್ ಆಫ್ ದ ಲ್ಯಾಂಡ್ ಬೇರಿಂಗ್ ಸರ್ವೆ ನಂಬರ್ 25
ಹೌದು ಸ್ವಾಮಿ,
to an extent of 3 acres.
ಹೌದು ಸ್ವಾಮಿ, ನನ್ನ ಸಬ್ಮಿಷನ್ ಇರೋದು ಈ ಟೆಂಪಲ್ ಇರೋದು ಆ 3 ಎಕರಲ್ಲಿ. ನಾನು ಈಗ ಅದು ಎಂಟೈರಿಟಿ ಕೊಟ್ಟಿದಾರಾ ಅಥವಾ ಪೋರ್ಷನ್ ಆಫ್ ಇಟ್ ಕೊಟ್ಟಿದಾರಾ? ಈ ಟೆಂಪಲ್ ಕೊಟ್ಟಿರೋದು ಆ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಇದೆ, ಎಂಟೈರಿಟಿ ಕೊಟ್ಟಿದ್ರೆ ಟೆಂಪಲ್ ಇರೋದು ಆ ಎಂಟೈರಿಟಿ ಇಲ್ಲಿ ಇದೆ ಅಂತ. ದಟ್ ಇಸ್ ಮೈ ಸಬ್ಮಿಷನ್. I'm not basing my submission on what is the total extent. ನಾನು ಏನ್ ಹೇಳ್ತಾ ಇರೋದು ಅಂದ್ರೆ 25 ಸರ್ವೆ ನಂಬರ್ 25 ಅಲ್ಲಿ ನನಗೆ ಬಂದಿರೋದು ಬರೀ 5 acres 36 ಗುಂಟಾಸ್. ಆ 5 acres 36 ಗುಂಟಾಸ್ ಅಲ್ಲಿ 0.01 ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಇರೋದು ಟೆಂಪಲ್ ಖರಾಬ್ ಲ್ಯಾಂಡ್. ಆ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ನನಗೆ ಬಂದಿದೆ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅದು ಬಿಟ್ಟು ಸರ್ವೆ ನಂಬರ್ 25 ಅಲ್ಲಿ ಇನ್ನೂ 10 ಎಕರ್ ಇದೆ, ಇನ್ನೂ 20 ಎಕರ್ ಇದ್ರೆ I have no connection with that. I am not claiming anything else beyond this 5 acres 36 ಗುಂಟಾಸ್. ಈ 5 acres
3 ನಿಮಿಷದ ಮುಂಚೆ ಮಾಡೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಗೆ ವಿರುದ್ಧವಾಗಿದೆಯಲ್ಲ.
My statement that I had made was the entirety of what has been given to me by virtue of this sale deed, my lord. All that piece and parcel anta ide. ಈ 25 ಅಲ್ಲಿ as per D1 ನನಗೆ 5 acres 36 ಗುಂಟಾಸ್ ಬಂದಿದೆ. ಈ 5 acres 36 ಗುಂಟಾಸ್ ಅಲ್ಲಿ 0.01 ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಇದೆ. That is my contention. And for that I have taken my lords through exhibit D1 where it clearly states ಈ ಎರಡು ಸ್ಟ್ರಕ್ಚರ್ ಇದೆ, ಸ್ಟೋನ್ ಮುನೇಶ್ವರ ಟೆಂಪಲ್ ಮತ್ತೆ ಸ್ಟೋನ್ ಮಂಟಪ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದ್ರಲ್ಲಿ ಅಸೆಸ್ ಮಾಡಿ ತಹಶೀಲ್ದಾರ್ಗೆ ನೀವು 575 rupees ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಅದನ್ನ. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ತಮಗೆ ಕೊಡ್ಬೇಕು, ಅದು ನಾನು ಕೊಡ್ತೀನಿ. ಬಟ್ ಫಾರ್ ನೌ ಇಫ್ ಐ ಕುಡ್ ಟೇಕ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಟು ಟೇಕ್ ಮೈ ಸಬ್ಮಿಷನ್, ನಾನು ಆ 575 rupees ಕೊಟ್ಟಿದ್ದೀನಿ. ಸೊ ಬೈ ವರ್ಚ್ಯೂ ಆಫ್ ದಟ್ ಈ 5 acres 36 ಗುಂಟಾಸ್ ಅಲ್ಲಿ ಏನೇನಿದೆ ಅದೆಲ್ಲ ನನಗ್ ಬಂದಿದೆ. 5 acres 36 ಗುಂಟಾ ಇನ್ ಸರ್ವೆ ನಂಬರ್ 25. That is all that I am basing my submissions on.
ಹಾಗೆ ಫಾರ್ ದ ಟೈಮ್ ಬೀಯಿಂಗ್ ಒಪ್ಪುವ ನಿಮ್ಮ 1 ಗುಂಟ ಮುನೇಶ್ವರ ಟೆಂಪಲ್ ಏನಿದೆ ಆ ಲ್ಯಾಂಡ್ ನಿಮಗೆ ಬಂದಿದೆ, ನೀವು ಅದ್ರ ದುಡ್ಡನ್ನು ಕೊಟ್ಟಿದ್ದೀರಿ. ಆದ್ರೆ ಮುನೇಶ್ವರ ಟೆಂಪಲ್ ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಆಫ್ ವರ್ಷಿಪ್ ಅನ್ನೋದು ಕಂಟಿನ್ಯೂ ಆಗಿದೆ.
Public use anta my lord, there is a difference because public place of worship andre under the public place of worship act ali, places of worship of act ali, it has to be designated as a public place of worship. It is not their contention that
repeatedly possession ಅಂತ ವರ್ಡ್ ಯೂಸ್ ಮಾಡಬೇಕಾದ್ರೂ ನಾನು ಅದನ್ನೇ ಹೇಳಿದೆ. ಲ್ಯಾಂಡ್ ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಮಾತ್ರಕ್ಕೆ ಯು ಆರ್ ಇನ್ ಪೊಸೆಷನ್ ಇವನ್ ಆಫ್ ದಿ ಟೆಂಪಲ್ ಆಲ್ಸೋ use the temple as you feel like ಅನ್ನೋದು ಬರೋಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ, I am not using the temple as I feel like, but what my submission is, it is not designated as a public place of worship as per that particular act for it to attract management ಮತ್ತೆ ಮುಜರಾಯಿ ಅದೆಲ್ಲ. What was my friend's submission on the last occasion? With due respect,
ಬನ್ನಿ ಈಗ ನೀವು ನನ್ನ ಪಾಯಿಂಟ್ ಗೆ ಬರ್ತಾ ಇದ್ದೀರಿ. ನನಗೆ ಏನ್ ಬೇಕಿತ್ತು ಫೀಡ್ಬ್ಯಾಕ್, ಅದಕ್ಕೆ ನೀವು ಬರ್ತಾ ಇದ್ದೀರಿ, ಸಂತೋಷ. ಎಕ್ಸಿಬಿಟ್ D1 ತೆಗೀರಿ. The entire point now lies in the internal phase 7 of exhibit D1.
yes
The
ma'am.
award.
Yes ma'am.
The first 2 lines.
Yes ma'am.
These buildings are left for public use.
Yes my lord.
They are not valued and the compensation is not determined.
Yes my lord.
Yes. What it denotes?
Sorry my lord, last part came.
Yes. What it denotes?
Yes my lord. May I submit my lord?
Yes.
When it says it's left for public use, it is not valued. I will use the earlier judgment that I placed before my lords. I'll rely on that to say valuation, since I cannot use this land. I have not been assessed for tax, hence it is not valued. And compensation is not determined under landowner ke compensation kottilla. Idru. So that is what these two means, that it is left for public use. Members of public can use it, even if this wasn't a temple. Assuming for a moment it's a passage. Adu aste, it is left for public use. That means that members of public can use. Not valued andre, I will not be paying tax because it has been acquired for me, but I will not be paying tax on that. It is not valued for taxation. Revenue purpose tax hakala, yakandre I cannot make use of that land. Compensation is not determined again for the same reason, that it is unarable land under 21(2)B of the land revenue rules. Adrinda it is not assessed for compensation to be paid to the landowner. In the same breath, later on, when assessment is done and when the order is passed, there is bifurcation, my lord. Heltare ishtirodna 1,80,000 something has to go to landowners. Adu civil court al deposit ಮಾಡಿ landowner or ownership prove ಮಾಡಿದ್ಮೇಲೆ ಅವರು ತಗೊಂತಾರೆ. Only with regard to 0.01 kharab. adu ಮಾತ್ರ ತಹಶೀಲ್ದಾರ್ ಕೊಡಿ. Since I cannot get that bit of land for free. ಅದನ್ನ give it to the Tashildar. However, till date, there is no assessment done on that. So this is my humble submission, how it is to be construed.
In such a place, maybe a public place of worship, or maybe in the acquired land, there is a stream is flowing, or maybe a footpath is there where the public make use of the acquired land handed over to you as a beneficiary of acquisition, but still that ingress and egress
Yes, ma'am.
would be there. Maybe if I crude energy can be given Brigade Millium near Konan Kunte or so. The acquired the land for Brigade Millium constructor, but there is a public road. The property in its entirety, the ownership may be vests with Brigade Millennium, but that is being used by the general public. In such a situation, here, incidentally, it is a temple. You may be the owner of the land, but what rights you have got over upon the temple? which is a public, which is for public use, then can you prevent even anyone coming over there or a person coming over there? Can you say that is an interference by them in your possession? What is the possession of these kind of properties? A place of worship for public use,
Yes, ma'am.
a footpath for public use,
Yes,
a
ma'am.
stream for public use.
Yes, ma'am.
Yes. What is the possession with respect to them? How the word possession has to be read and understood?
Yes, ma'am. Obliged, my lord. If I could borrow my lord's example of Brigade Millennium,
Yes.
just for better
I do
clarity.
not know whether that example tallies with this, but crudely I have given. Yes.
Yes, madam. So if we take Brigade Millennium, ivaga alli ಒಂದು footpath ಇದೆ ಅಥವಾ right of access way ಇದೆ. Now that is for public use. Can some members of the public come tomorrow and say ಈ road ಅಲ್ಲಿ pothole ಇದೆ, ಈ road ಅಲ್ಲಿ speed breaker ಹಾಕಿಲ್ಲ, ನಾವು ಹಾಕ್ತೀವಿ ಅಂತ? Can they come and then dig up the road and lay something there, or can they put speed breakers, or they say illa this tar sari hogalla, I will put another interlocking tiles anta? Will members of the public, merely because they have a right of public use, do they have the right? I ask myself this question to come.
No, I am expecting answer from you. That's what my question is.
I will pose myself this question and I will answer it.
Yes.
So will members
One
of the public?
example is Brigade Millennium, another is Jalhalli Air Force.
Yes, my lord. Jalhalli Air Force adre alli there is a difference yakandre that has been relinquished. In fact, illu aste ee scheduled property, larger property li relinquishment deed agi roads ella avrige hogide. BDA maintain ಮಾಡ್ತಿದೆ. So that is, I'm not even going to touch on that. So adik paralla, so I will not take Jalhalli's idu, but even now for Brigade Millennium nodidre ivaga, or even if it's a stream, natural lake ಏನಾದ್ರು ಇದ್ದು ಅಲ್ಲಿ Brigade Millennium ಅಲ್ಲಿ lake ಇದೆ ಅಂತ ಅನ್ಕೊಳ್ಳಿ, ಅವಾಗ್ಲೂ ಅಷ್ಟೇ, can somebody come say ಇದು for public use, ನಾನು ಇಲ್ಲಿ ಬೋಟ್ ನಡೆಸ್ತೀನಿ paddling ಮಾಡಕ್ಕೆ, because it's public, I'm member of the public, I will provide these services to the idu. Such an action cannot be taken by a member of the public claiming that this is public land, so it can be used how I want. There's a difference. This is private land with public use. So Brigade Millennium owns the stream, Brigade Millennium owns the road, but public use. If Brigade Millennium then says illa yaru stream bandu enjoy madakagala andre, there is a problem there. Avaru bandu helidre yaru ee road use madakalla andre, there is a problem. Iga my client says yaru bandu illi you cannot offer prayers, there is a problem. But that is not the situation. Instead, members of the public, allegedly the defendant claims to be members of the public, they have, it is just one respondent number 3, my lord, there is nobody else that is there. He claims to say
example nalli Brigade Millennium road alli potholes agide, inneno agide. A public cannot go and say that say we are putting the cement road there or interlocking tiles, etc. Can they be permitted, or can they be allowed? I put another question.
Yes, ma'am.
If an accident takes place there due to some pothole, and the person who met with the accident, he sues Brigade Millennium. He says that say you have not filled the pothole, because of that pothole I fell down with my two-wheeler, the pillion rider died, pay 30 lakhs rupees compensation.
Yes, my lord.
Then according to whether Brigade Millennium is liable to pay?
There would be liability, my lord. There
Because you
would
want
be
to win this
liability
case.
because it is the ownership. The ownership lies with that. If there is somebody, there is a stream, iga road sort of BBMP ಹೋಗುತ್ತೆ ಕೆಲವು time, so even a road ತೆಗೆದು Brigade Millennium stream ಇದೆ ಅಂತ ಅನ್ಕೊಳ್ಳಿ, stream ಇದ್ದಾಗ ಈಗ some members of the public go there, they drown there, and then can they file something against Brigade Millennium stating that you have not maintained it properly, safety ಇದು ಹಾಕಿಲ್ಲ ಅಂತ? I would say it is my submission that Brigade Millennium would be liable. There would be some amount of liability because it is my property. Nan property ಬಂದು ಏನೋ ಆಗಿದೆ ಅವರಿಗೆ, so I am responsible for it. If I have not maintained it safely, then it is my responsibility. Nanna property lagide adu. I am grateful for my lord's example. That is precisely the point. Who will take liability? Ella enjoyment anta heltidare.
No, how do you substantiate your argument?
In terms of
support of
when I look
law,
at tort law,
proceeding.
when I look at tort law, my lord, when I look at tort law, if something happens on my
In this case, it's not just the tort law that is
Allala, example alla aste.
4 ಹಿಯರಿಂಗ್ ಇಂದ ಇಬ್ಬರಿಗೂ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ, ಯಾವ್ಯಾವೆಲ್ಲ ಅಪ್ಲೈ ಆಗ್ತದೆ ಇದರಲ್ಲಿ ಅದನ್ನು ಫಸ್ಟ್ ಐಡೆಂಟಿಫೈ ಮಾಡಿ. ಒಂದೊಂದು ಕ್ಲೂ ನಾನು ಹೇಳಿದಾಗ ಒಂದೊಂದು ನಾನು ಎಕ್ಸಾಂಪಲ್ ಕೊಟ್ಟಾಗ ಅದಕ್ಕೆ ಟಾರ್ಕ್ ಲಾ, ಇದಕ್ಕೆ ಕಂಪನಿ ಲಾ, ಇದಕ್ಕೆ ಪೀನಲ್ ಕೋಡು, ಅದು ಅಲ್ಲ ಪ್ರಶ್ನೆ. ಇಂಥದ್ದು ಬಂದಾಗ ಇದರಲ್ಲಿ ಯಾವೆಲ್ಲ ಅಪ್ಲೈ ಆಗ್ತದೆ? ನಿಮ್ಮ ಪ್ರಕಾರ ಓನರ್ಶಿಪ್ ವೆಸ್ಟ್ ವಿತ್ 1%.
ಹೌದು.
The superstructure is meant for public use.
The public use is permitted. That does not mean superstructure belongs to the public. It is my.
I did not say belongs to the public. Superstructure is meant for public use.
Yes, ma'am. Deeply obliged.
Is meant for public use and then
ಹೌದು.
belongs to public ಅಂತ ಇನ್ನೂ ಹೇಳಿಲ್ಲ ನಾನು. ನೋಡೋಣ ಅದು ಯಾರಿಗೆ, ಆಮೇಲೆ ನೋಡುವ.
Thanks.
ಆ ರೀತಿ ಬಂದಾಗ what are the relevant clause that is applicable? It is a public place of worship belonging to a particular religion. There are several laws applicable to the places of public places of worship of different religion. Whether that law speaks anything about the maintenance of the public places of worship, maintenance of the properties which are for public use for worship. If you are bifurcating public place of worship and the place for public use.
Yes, ma'am.
Place for public use, if it were to be the purpose for worship, then which are all the law that is applicable? Who is said to be in possession, lawful possession? The mere title holder would be a person to be called as lawful possession, or the alleged possession can be claimed by a endowment or charity commissioner or mujrai, the possessor responsible to maintain and manage. So what is that possession? That has to be clarified.
Yes, ma'am. It is my humble submission, my
That
lord.
is what say, since for the past 4 hearings I have been telling.
Yes, madam.
Yes.
It is my humble submission that none of these acts, that public places of worship act, is not applicable to the instant case. The temple itself is not notified under that act. Unless my friend has something to show to that effect, I'm making a responsible statement that it is not applicable to the temple. It has to be specifically notified under the provisions of the act before it comes under the Mujurai department. If it comes under the Mujurai department, then there is a certain endowment that will be given to the pujari who will do puja ali. That has not happened till date. That is not the case, because this is a temple situated on private land. In fact, a few hearings ago, I had given an example of a temple being in a private residence and how it was open to public use. It is still date open to public use, but that does not mean that public can claim possession or ownership. They have a right of worship, but that is about it. There isn't anything in addition to that. So very responsibly, I'm making this statement, my lord. This is a unique situation where there is a temple structure on private land. It does not come within the state's Mujurai department, Religious Endowments Act, Athwa public places of worship. It is not notified as such. I am the owner, and with ownership comes possession. There is no differentiation either in the order or in my sale deed. It does not say you have possession only of X amount of the land, but not 0.01 kharab land. With due respect, my lord, my sale deed does not say that. So it's my humble submission that for all purposes, the applicable law would be the Karnataka Land Revenue Act and the land revenue rules thereafter. Beyond that, there is nothing that applies to my situation. This is my submission.
Whether Exhibit D1 says that though Muneshwara Swami temple and stone mandapa are considered to be for public use, however, that land is the subject matter of acquisition.
When the award is passed and when the order is passed in the same D1, it clearly states all that is there within survey number 25, extent of land measuring 5 acres 36 kuntas of dry land situated so and so. So it clearly states that there is no exception that is made. It's my humble submission. And I would request this court to give me the benefit of that, of the fact that when the order does not make an exception that this does not belong to you, because the authority is aware that these structures are there and it is aware that it has public use. Adu was paramount on their mind, and they have said, either I will not give compensation, I will not value it, it will be left for public use. However, all this is given to, and when I mean all this, I agree, there is nothing that says Muneshwara temple, stone mandapa, adunu hogutte anta. What I'm taking advantage of, or I seek indulgence from this court, is with regard to survey number 25, 5 acres, 36 kuntas, Muniswami temple, stone mandapa comes within. So when 5 acres, 36 kuntas within those boundaries come to me, this also has come to me. I am the owner. I am in possession. I am leaving it open for public use. Does not mean some miscreants from the public can come usurp it to their own ends. Asteso.
Yes, responding, sir.
The suit which has been filed by the plaintiff claiming ownership in respect of the scheduled property, which is a temple which exists in survey number 25. The relevant portion
You appear for all the 4 respondents.
That's last one.
Which respondents appear?
One second. One second.
Only 3. ನಾಳೆ ಅದನ್ನ ಅವ್ರು ಹೇಳಿ ಆಮೇಲೆ ಎಲ್ಲ ಮಾಡಿ ನಾನು ಹೇಳಲಿಲ್ಲ ಅದು ಅವ್ರು ಹೇಳಿದ್ರೆ ಹೇಗೆ
Only 3.
Only 3.
Yes.
Are there counsels for the other respondents, or have they been served and remained unrepresented? Respondent number 1, 2 and 4.
They have been served but remained unrepresented.
Yes, now the contesting respondent is only R3.
Yes,
yes.
Proceed, please.
This is a suit for perpetual injunction in respect to the property which is the subject matter of the suit. The subject matter of the suit is a temple situated in survey number 25 in an area measuring, said to be measuring 12 by 12.
Yes.
12 by 12 feet. The bone of contention of the plaintiff in the plaint presented by them before the trial court is, we are the owners of the property. We acquire title to the property by virtue of the sale deed which has been executed by the BDA, and we have paid and purchased the same under the sale deed dated 18/11/1992. That sale deed has been produced and marked as Exhibit P1.
Yes.
P2.
Yes.
Paid and purchased.
Yes.
But the relevant portion of the plaint governments with regard to the ownership.
Yes.
Would be seen at para number 16 of the plaint. Para number 16.
Yes. Yes.
Blood. The second contention that they have purchased the property by paying the money could be seen at para number 7 of the plaint. Paid and purchased the scheduled property.
1 minute.
Para number 7.
Para number 7 of the plain.
Para number 16 and 7. ಮುನೇಶ್ವರ ಟೆಂಪಲ್ ನಾವು ದುಡ್ಡು ಕೊಟ್ಟು ಕೊಂಡ್ಕೊಂಡಿದ್ದೀವಿ.
ಮುನೇಶ್ವರ ಟೆಂಪಲ್ ನ ದುಡ್ಡು ಕೊಟ್ಟು ಕೊಂಡ್ಕೊಂಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇನ್ನೊಮ್ಮೆ ಓದಿ, ನಾನು ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಸ್ ಇದೆ ಇದು. ಅವ್ರ ಪ್ರಕಾರ ಹೌದು, ನೀವಾಗ ಹೇಳಿರೋ ಖುಷಿಯಿಂದ ಹೌದು ಅಂತಾರೆ. ಆದ್ರೆ ಪ್ಲೀಡಿಂಗ್ ಆ ಸೆಂಟೆನ್ಸ್ ಒಮ್ಮೆ ಓದಿ. ಪ್ಯಾರಾ 7 ಅಲ್ಲಿ.
It is para number 7.
7.
It is respectfully submitted there is a Maneshwara temple situated at the entrance of the Sena Vihar residential complex near the western gate, which is under the maintenance management administration of the same by the first plaintiff and predecessor society.
1 ನಿಮಿಷ ಅಲ್ಲೊಂದು ಬ್ರೇಕ್. ಇಲ್ಲವ್ರು ಇನ್ನು ಓನರ್ಶಿಪ್ ಅಂತ ಹೇಳಲಿಲ್ಲ ಅಲ್ವೇ? ಮೇಂಟೆನೆನ್ಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ದ ಸೇಮ್ ಬೈ ದಿ ಫಸ್ಟ್ ಪ್ಲಾಂಟಿವ್.
ಪೂರ್ತಿ ಓದ್ಬಿಡಿ.
ಮುನೇಶ್ವರ ಟೆಂಪಲ್ ಓದಿ, ಈಗ ಮುಂದೆ ಓದಿ.
ಒಂದ್ಸಲಿ ಪೂರ್ತಿ ಓದ್ಬಿಡೋಣ. If I am wrong, I am prepared to apologize.
ರಾಂಗ್ ಅಲ್ಲ,
I am prepared to apologize.
ಓನರ್ಶಿಪ್ ಅಂತ ಅವ್ರು ಹೇಳಿಲ್ಲ ಅಂತ ನಿಮ್ ಸಹಾಯಕ್ಕೆ ಬಂದೆ ನಾನು.
Which is under the maintenance, management and administration of the same by the first plaintiff and predecessor society and its members and residents, and offering daily prayers to the Almighty. The aforesaid temple is situated upon the land and which is paid and purchased by the owners of the plots and the independent plot house owners through the AHO BDA from BDA. From BDA. Supra. The same is only registered in the name of the owners along with the individual shares, title, interest and possession over the common areas of the residential complex, including the temple supra, and hence the temple along with all other common areas are maintained, managed, administered by the first plaintiff association in consonance with the bylaws filed by the members being the owners of the plots and independent plots situated in the Sena Vihar residential complex mentioned supra. The aforesaid temple is more fully described at the schedule and herein after referred to.
Yes.
Your Lordship may kindly see. The intrinsic value of the pleadings contained in para number 7 is the property that has been purchased by AHWO includes the temple, and we have paid and purchased it. Your Lordship may kindly, the question that needs consideration at the hands of this honorable court is whether entire land in survey number 25, which was notified and acquired, was handed over to them. There is no material on record which has been placed by the plaintiff before the trial court. Entire land in survey number 25, which was notified and acquired, which was handed over to them. These lands, chunk of lands, were notified by the Bangalore Development Authority for formation of Ennur Banswadi layout. This is not a chunk of land which has been individually notified and acquired for the benefit of them. Huge extent of land notified and acquired in the year 1980. 78 is the preliminary notification. 80 is the final notification. ಎರಡು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. 81 ಇದೆ, 19th ಅನ್ನು ಒಂದ್ ಕಡೆ ಹೇಳ್ತಾರೆ ಅವಾರ್ಡ್ ಅಲ್ಲಿ. So a larger vast extent of land has been notified for Hennur Banswadi layout. After acquiring portion of the land measuring about 14 acres 22 guntas, comprising of several survey numbers, seems to have given on lease in favor of this association, not sale. Not sale. Irrespective of it, 14 acres 22 guntas comprises of several survey numbers. However, in survey number 25, the existence of the temple, and which is a place of public worship, has been notified while acquiring and has been reiterated in the award which has been passed by the authority. So there is a foundation to the affair that there was a public place of worship in survey number 25. At the cost of repetition, my learned friend has showed it. Exhibit D1. But before going to the award, my lord, this is an acquisition of 1980. Award came to be passed in 1993, 17/9/1993. Presupposes the possession has been taken subsequent to it. However, an allotment has been made, chunk of land in favor of the society in the year 1986 itself. Exhibit P37. Even before taking possession of the property by the Bangalore Development Authority, a formal allotment has been made. Exhibit P37. Their sale date even earlier to award, that is on 18/11/1992, whereas the award is on 17/9/1993. Exhibit P2 nalli the consideration Lease amount, the lease amount has been shown as 28 lakhs. 28,07,285. That is in exhibit P2. $28 ಲಕ್ಷದ 7,285 ರೂಪಾಯಿ. ಬರುತ್ತೆ. P2. With P2 ನಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ 158 ಅಲ್ಲಿ ಕನ್ಸಿಡರೇಷನ್ 158.
The dates of acquisition, dates of notification, the dates of allotment, the quantum of the consideration paid under some of the sale deeds, maybe including exhibit P2. How far they are relevant for this?
It's not relevant. What my submission to my lord is, even before acquisition, this deed or the sale deed has been executed by the PDA. Taking note of this same, at the day when the PDA has executed the lease deed or the possession certificate, the PDA itself was not in possession of the property, and they are contained. We came into possession under the sale deed of 1992. There is a fishy with regard to the possession.
You are attempting to widen the scope of this.
ನಾನು ಹೋಗೋದೇ ಇಲ್ಲ, ಅದು ಬಿಟ್ಬಿಡ್ತೀನಿ.
Attempt to create some loopholes in the case of the client.
Now only the question is the place of worship, public worship.
Yes, we have to proceed.
Yes.
From the time of delivering them the possession of the land under the acquisition.
Yes, my lord.
And thereafter.
I will not trouble the court to travel beyond the scope of temple. I humbly request my lord, kindly take out the Karnataka Hindu Religious and Institution. Section 227 definitions. 2 ನಲ್ಲಿ 27. We restrict it. Only two definitions under this act is relevant.
Yes.
One is definition with regard to the temple, and another is family temple. I will show both the definitions.
Yes.
Maybe read
Family temple is 14B.
14B, yes. 14 or 14B.
214B.
Yes. Family temple adre. Family temple means any temple established or maintained exclusively by the members of any family, either by themselves or by family trustees, consisting of family members only.
Somebody says world is a family. Yes.
In the temple. In the temple. I had an occasion to conduct a case relating to a temple which has been constructed on a public property. which was managed by a private trust, the members. It is nothing short of Mahalakshmi Layout Anjaneya Swami Temple, Lord Anjaneya Swami Temple. The Archik who was managing the temple has claimed exclusive right over the temple. And he has collected more than about 15 kgs of gold. Idana tower collected it and stored it. Public have donated it. Ellaru onond gram kodabeku, maneyavarella onond gram kodabeku anteli ondu. Hundi collection was so much in the temple. And it was brought to the, when he has misutilized, it was brought to the notice of the authorities. Authorities did not choose to take any action. We approached the division bench of this honorable court, public interest litigation. Court intervened and directed the deputy commissioner to notify the temple. Then it was notified. The charge was taken over. This is a public temple. Because it is situated in a public property, CH-07, ಅಲ್ಲಿ ಒಂದು park ಇತ್ತು, park ಅಲ್ಲಿ ದೇವಸ್ಥಾನ ಕಟ್ಟಿ. Then it was taken over by the government. Then revenue collected. He was showing 8 to 9 lakhs per year. It was accruing more than 20 to 22 lakhs in a month. Then the property was taken over and he was sent out. And even the gold was also collected. He had kept it in the thing. So therefore, a temple which is constructed on a public property would never become the private one. It never fall into the private ownership. That is the situation. So temple has been said it in the award itself. So now with that background, I will read the definition of temple. Temple means a place of, by whatever name called, used as a place of public religious worship, having separate existence and dedicated to or for the benefit or used as a right by Hindu community, as a right by the Hindu community or by any section thereof as a place of public religious worship, and includes the mandira, samadhi, vrindavana, Gadige, shrine, subshrine, Utsav, Mantap, tank, Utsav Mantap, tank, Paduka, Pita, Devasthana, Gudi, Gorodi, are necessary appurtenant structures and land. So this is the definition of temple. So therefore, Muneshwara temple finds a place in the award. So therefore, it is not a family temple. It is a public temple, which is a temple worshipped by the general public.
You make any difference between use and worship with respect to a temple? Use of a temple, worship of a temple.
Used as a right. Right. We are using it as a right. We are going to the temple and using it as a right. Inherent right which has been developed in the community. Place of worship as a right, human right. Now, the plaintiff has approached this honorable court. Entire land in survey number 25 has been handed over. Award ನಲ್ಲಿ 1,87,000 ರೂಪಾಯಿ ತಗೊಂಡಿದ್ದಾರೆ. 5 ಎಕರೆಗೆ 5 ಎಕರೆಗೆ ಎಷ್ಟು? 5 ಎಕರೆ 22 ಗುಂಟೆನಲ್ಲಿ ಅಕ್ವೈರ್ ಆಗಿರೋದು. 342 ಬರಬೇಕು ಅವಾರ್ಡ್ಗೆ. Just read the award portion at section 11 of the Land Acquisition Act. Ali. A ಮತ್ತು B ಅಂತ ಮಾಡಿದೆ. Compensation allowed for land is at rupees 28,000 per acre. Dry land 5 acres 25 guntas.
Which document you are reading?
Award D1.
Exhibit D1.
Exhibit D1.
Internal page.
ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ
Award portion is internal page 7.
Yes, sir. ಇದ್ರೊಳಗೆ ತಾವು ನೋಡ್ಬೇಕಾಗಿರೋದು ಒಂದೇನೆ 1,87,450 ರೂಪಾಯಿ. Land owner awarded in favor of the land. So, ಇದಕ್ಕೆ ಮುಂಚೆ 86ನೇ ಇಸ್ವಿಲೆ BDA-ನವರು 92ರಲ್ಲಿ they have collected 28 lakhs from them. In 1993, award has been passed for 1,87,000 and died in favor of the land owners. So these two, there is no match at all. 14 acres ಅಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ. ಇಲ್ಲಿ 5 ಎಕರೆಗೆ
ಹಾಗಾದ್ರೆ ನೀವು ಅವಾರ್ಡ್ ಚಾಲೆಂಜ್ ಮಾಡಿ ಕ್ಯಾನ್ಸಲೇಷನ್
ನಾನು ಅದನ್ನು ಕೇಳ್ತಾ ಇದ್ದೆ.
ಮತ್ತೆ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ನಲ್ಲಿ ನೀವು ಮೋರ್ ಆನ್ ದಿ ಟೈಟಲ್, ಮೋರ್ ಆನ್ ದಿ ಓನರ್ಶಿಪ್, ಮೋರ್ ಆನ್ ದಿ ಅಕ್ವಿಸಿಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ ಅದ್ರ ಮೇಲೆ ನಾವು ಕಾನ್ಸಂಟ್ರೇಟ್ ಮಾಡಿದ್ರೆ
we are not on that point also. Now the question is, it is a simple suit for injunction.
Yes.
It is a place of worship. It is a concluded fact. They are claiming exclusive right over the property. Don't enter. Grant an order of injunction. They are third parties. It is our property. We have purchased it. But such an order of injunction could be granted against a place of worship. Whether the court can restrict an entry to the general public in worshipping the, including the defendant.
ಒಂದು ನಿಮಿಷ, ಸಾರಿ ಫಾರ್ ಇಂಟರ್ಫಿಯರೆನ್ಸ್. The moment the learned counsel for the appellant commenced her argument, the very first sentence of her argument was that the plaintiff never restrains or obstructs any of the devotees from worshipping the deity. In fact, we have not restrained anybody, are not going to restrain anybody or prevent anybody from having access to the temple. But we are only preventing them, or say our objection is taking the control of the temple, its management, administration, or putting up any new structure there, which nobody else can do. That is what her opening statement was, and that is the reason on the previous couple of 2 hearings also, some suggestions were made whether any possibility of settlement is there, kindly look into. Therefore, you are now the present statement that can they prevent anybody from going to the temple doesn't arise, because they are not, as stated before the court, from the bar, they are not preventing anybody from going to the temple.
That is not the plight. What has been argued before my lord is not the averment in the plight. We have to go with the averment in the plight.
Are you prepared to file an affidavit stating that you are not preventing anybody, any person from visiting the temple and worshipping the deity? Can that be permitted?
This next question is, the roads have been formed. The roads have been formed within the area. While leasing the property by the BDA, BDA has said it, till the area is handed over to the Bangalore Development Authority, you should maintain it. You should maintain the roads. The area has been handed over to the BBMP long ago by virtue of a notification. Relinquishment deed ಕೊಟ್ಬಿಟ್ರು ಆಗೋಯ್ತು. Exhibit P3 relinquishment deed ಕೊಟ್ರು, that all vested with the government. When all the roads are vested with the government, can you claim any exclusive right over the road also? Section 30 of the BD Act.
No, have they claimed exclusive right over the road? What is
Gate
the claim?
ಹಾಕ್ತಾರೆ. Gate ಹಾಕ್ಬಿಟ್ಟು they are preventing the persons who comes to offer puja to the deity. And now watchman ಕೇಳಬೇಕು ಅವ್ನು ಬಿಟ್ರೆ ಹೋಗ್ಬೇಕು ಇಲ್ದ್ರೆ ಹೋಗಿಲ್ಲ.
ಇಲ್ಲರನ್ನು ಹೋಗಿ ಬಹಳ ಗಲಾಟೆ ಮಾಡ್ತೀರಿ ಅಲ್ಲಿ. ಹೊತ್ತಲ್ಲೆಲ್ಲ ಹೋಗೋದು, ಏನೋ ಉತ್ಸವ, ಏನೋ ಸಮಾರಾಧನೆ, ಇನ್ನೇನು ಮಾಡೋದು ಅಲ್ಲೆಲ್ಲ ಮತ್ತೆ ಬೇರೆ ದೇವರ ಉತ್ಸವನ ಇದರಲ್ಲಿ ಬೇರೆ ಚಟುವಟಿಕೆಗಳು ನಡೀತದೆ. ಇಡೀ ದಿವಸ ರಾತ್ರಿ ರೆಕಾರ್ಡ್ ಹಾಕೊಂಡು ಭಜನೆ ಗಿಜನೆ ಇತ್ಯಾದಿ ಇಂತೆಲ್ಲ ಮಾಡ್ತೀರಿ. ದೇವರಿಗೂ ಸ್ವಲ್ಪ ನಿದ್ರೆ ಇದ್ರೆ ಬೇಕಲ್ವೇ?
ದೇವ್ರಿಗೂ ನಿದ್ದೆ
ನೋಡಿ, ಇದು ಎಲ್ಲಾ ಕಡೆ ಇರ್ತಕ್ಕಂತ ಪ್ರಾಬ್ಲಮ್. ಎಲ್ಲಾ ಕಡೆ ಇರ್ತಕ್ಕಂತ ಪ್ರಾಬ್ಲಮ್. ಎಲ್ಲಾ ಕಾಲೋನಿಗಳಲ್ಲಿ ಎಲ್ಲ ಕಡೆಯೂ ಕೂಡ ಒಂದು ದೇವಸ್ಥಾನ ಅಂತ ಮಾಡಿದಾಗ ಯಾರೋ ಮಾಡ್ತಾರೆ, ಏನೋ ಒಂದು ಉದ್ದೇಶದಿಂದ ಮಾಡ್ತಾರೆ. ನಾಡಿದ್ದು ಇನ್ನೊಬ್ರು ಯಾರೋ ಬೇಸಿಕಲಿ ಸೂಟ್ ಈಸ್ ಬೈ ದೆಮ್. ಅವ್ರು ಹೋಗಿ ಗೇಟ್ಗೆ ಬೀಗ ಹಾಕ್ತಾರೆ, ನಮಗೆ ತೊಂದರೆ ಕೊಡಲ್ವೇ, ಅವ್ರು ನಮ್ಮನ್ನು ಒಳಗಡೆ ಬಿಟಗಳಲ್ವಾ ತೊಂದರೆ ಕೊಡಲ್ವೇ ಅನ್ಲಿಕ್ಕೆ ಸೂಟ್ ಅವ್ರು ಹಾಕಿರೋದು. ನಿಮ್ ಇಂಜಂಕ್ಷನ್ ಕೇಳಿ, ನೀವು ಹಾಕಿರೋದಲ್ಲ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜಂಕ್ಷನ್ಗೆ. ನಿಮ್ಮ ಸೂಟ್ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜಂಕ್ಷನ್ ಆದ್ರೆ ಅಲ್ಲೊಂದು ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಆಫ್ ವರ್ಷಿಪ್ ಇದೆ, ನಮಗ್ ಹೋಗ್ಲಿಕ್ಕೆ ಅದು ಪಬ್ಲಿಕ್ ರೋಡ್ ನಲ್ಲಿ BBMP ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ರೋಡ್ ನಲ್ಲಿ ನಾವು ಹೋಗ್ಲಿಕ್ಕೆ ಅವ್ರು ಗೇಟ್ ಹಾಕೊಂಡು ನಮಗೆ ತೊಂದರೆ ಕೊಡ್ತಿದ್ದಾರೆ. ಅದು ಕರೆಕ್ಟ್. ಸೂಟ್ ಅವರದ್ದು, ಪ್ಲೈಂಟಿಫ್ ಅವರದ್ದು. ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಈ 12/12 ಟೆಂಪಲ್ ಮಾತ್ರ, ರಸ್ತೆ ಗಿಸ್ತೆ ಏನೂ ಅಲ್ಲ, ಅದ್ಯಾವುದು ಈಗ ಡಿಸ್ಪ್ಯೂಟ್ ನಲ್ಲಿ ಇಲ್ಲ. ನಿಮಗೇನಾದ್ರೂ ಅವ್ರು ಗೇಟಿಗೆ ಬೀಗ ಹಾಕ್ತಾರೆ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಸಪರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಇದೆ, ನೀವು ಅದನ್ನ ಕೋರ್ಟಿಗೆ ಬರಬೇಕು. ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು 12/12 ಟೆಂಪಲ್ ನಲ್ಲಿ ನಮ್ಮ ಪೊಸೆಷನ್ ನಲ್ಲಿ ಅವ್ರು ಇಂಟರ್ಫಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ, ಅದನ್ನ ಪ್ರಿವೆಂಟ್ ಮಾಡಿ. ಅಷ್ಟೇ ಆಗಿರೋದ್ರಿಂದ ನಾವು ಸುತ್ತಮುತ್ತಲ ರೋಡು ಅವ್ರ ಗೇಟಿಗೆ ಬೀಗ ಹಾಕ್ತಾರೋ ಮತ್ತೊಂದು ಮಗದೊಂದು, ಅದನ್ನ ಬಹುಶಃ ಈ ಸೂಟಿನಲ್ಲಿ ನಾವು ಅದನ್ನೆಲ್ಲ ಆಲೋಚನೆ ಮಾಡಿ ಅದನ್ನೆಲ್ಲ ತಲೆಯಲ್ಲಿ ಇಟ್ಕೊಂಡು ನಾವು ಜಜ್ಮೆಂಟ್ ಬರೀಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ನಾವು ಜಜ್ಮೆಂಟ್ ಬರಿಬೇಕಾಗಿರೋದು 12/12 ಅವರ ಲಾಫುಲ್ ಪೊಸೆಷನ್ ನಲ್ಲಿ ಇದೆಯಾ, ಅದರಲ್ಲಿ ನಿಮ್ಮದು ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಅನ್ನೋದು ಇದೆಯಾ. ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಕಾನ್ಸೆಪ್ಟ್ ನಲ್ಲಿ ವೆನ್ ಎನ್ ಅಕ್ವೈರ್ಡ್ ಲ್ಯಾಂಡ್, if even after assuming for a moment, not admitting, assuming for a moment that 5 acres 36 guntas of land includes this 0-01 guntas of land measuring 12/12, then can the plaintiff claim the exclusive possession over the building upon it, which is the temple, to the exclusion of others? Possession, right of possession.
That is all the question request to be.
And whether a devotee going to the temple, does it amount to interference in their alleged possession? If their contention is that we are not preventing any devotee coming there and worshipping. If a devotee makes a Mangalarti, probably we may not have anything. But he want to make some alteration in the structure of the temple in the guise of either improvement or modification, renovation, whatever it may be. We have that. That has to be seen by the court. What in the instant case the alleged interference is. So confining to the plaint, what is alleged to be as interference, whether does it amount to interference? That is all the
question.
That is all.
There is no material on record to establish the entire 5 acres 36 guntas was handed over to them. There is no material on record. What are all the extent of other survey numbers, and what is the extent of survey number 25, which has been handed over to them?
You mean to say there is no material to show that an extent of 5 acres 36 guntas was handed over to them, or you mean to say that the alleged extent of 5 acres 36 guntas does not include this attempt? Yes. Which is your argument? Two are totally two different aspects.
Your Lordship, may kindly say, absolutely there is no material on record. The entire land in survey number 25 was handed over to them. There is no material. Secondly, they have no exclusive right over the scheduled property. Exclusive right over the scheduled property. This has not been conveyed to them.
So the learned counsel's argument at the conclusion was that forget what is the total extent of survey number 25, but In survey number 25, 5 acre 36 guntas of land was acquired and the entire 5 acre 36 guntas of land was given to society, and that 5 acres 36 guntas of land includes the scheduled property land also. That is their argument.
If it is included,
Ah.
if it is included, let them demonstrate. Let them demonstrate that this is also included and this is also sold. So while passing the award, even assuming that it is included, can they claim exclusive right over the temple portion? Temple portion is a reserved crop. Reserved crop will not lose its character forever in view of section 67 of the Land Revenue Act.
Reserved crop can be owned by individual or the society, right?
The
Food
reserved
crop can be owned and possessed by an individual.
No, there is a bar, section 67. Only the thing is the government can change the use of land from one character to another.
No, not the use of land, sir. Kindly don't confuse between
Ownership baradilla.
use of the land or the nature of the land to the top, the ownership.
Your Lordship, kindly see the reserved crop, that is B crop, totally vest with the government.
If my RTC says, I have got 5 acres of land with 15 guntas of food crop attached to that. My RTC says 5 acres, 15 guntas standing in the name of Prabhakara Shastri. Then do you mean to say that I am the owner of only 5 acres of land, 15 guntas of land is not my land, that is government land. And anybody can come and camp their tent in that particular 15 guntas of land.
Suppose if there is a nala, if there is a road, if something, a river is there, tank is there, it is excluded under section 67 of the Land Revenue Act. I will just read and show it to the board about the position of law with regard to the reserved crop.
Please. Of the judgment.
59-16, specifically with regard to 67. The question that my law is posing.
Yes.
There is exposition.
Public roads.
1 minute. Which para you said?
Paragraph 59.
From the section 67, we'll continue this afternoon.
Yes.
My lord. My lord.
Yes.
Apologies for the indulgence, my lord. I'm appearing in serial number 24, my lord. I'm appearing on behalf of the appellants, my lord. Due to personal injury, I was unable to appear in person in the court, my lord. I need to file paper book in that case, my lord. May 2 to 4 weeks. Time
Serial
will be
number?
granted, my lord. 24, my lord. Serial number
Order
24,
has been
my lord.
passed.
My lord, my
Order
sincere
has been passed
apologies.
in that matter.
My lord,
Yes.
sincere apologies, my lord. Due to injury, I
No,
was
no,
unable to
no,
come,
no
my lord.
submissions, please. Order has been passed. Yes.
Serial number 45, my lord.
Don't. ಮ್ಯಾಟರ್ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಅಲ್ವಾ? ಮಧ್ಯಾಹ್ನ ಕಾಯ್ಬೇಕಲ್ವೇ? ಸೀನಿಯರ್ ವಕೀಲರುಗಳ್ರಿ, ನನ್ನ ಏಜ್ ಗಿಂತಲೂ ಜಾಸ್ತಿ ಆಗಿರ್ತಕ್ಕಂಥವ್ರು ಪ್ರಾಕ್ಟೀಸ್ ನಲ್ಲಿ ಅಂತವ್ರು ಕಾಯ್ತಾರೆ. ನೀವೆಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇರ್ತೀರಿ, ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಎಲ್ಲದನ್ನು ಮುಗಿಸ್ಬೇಕು. ಅದು ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ಗಳು ಅಟೆಂಡ್ ಮಾಡೋದಿರ್ತದೆ, ನಿಮಗೆ ಟ್ವಿಟರ್ ನೋಡೋದಿರುತ್ತೆ. ಮ್ಯಾಟರ್ ಪಾಸ್ ಓವರ್ ಅಂತಿದ್ದಾಗ ಅದನ್ನ ಕಾಯ್ಬೇಕಲ್ವೇ? ಶೇಷಗಿರಿ ರಾಯರೇ, ನಿಮ್ಮನ್ನ ಬೈತೇನೆ ನಾವು, ಹಳಬರು ಏನ್ ಕಲ್ಸಿದ್ದೀರಿ ಅಂತ. ಎಷ್ಟು ಉದಾತ್ತವಾದ ಮೌಲ್ಯ ಇದೆ ಗೊತ್ತಾ ಈ ಬಾರ್ನಲ್ಲಿ. ಎಷ್ಟು ಮ್ಯಾಟರ್ ನೋಡ್ತೇನೆ ನಾನು, ಯಂಗ್ಸ್ಟರ್ಸ್ ಮಾತ್ರ ಹೇಸ್ಟಿನೆಸ್ ತೋರ್ಸೋದು. ನಾನೆಲ್ಲ ಪ್ರಾಕ್ಟೀಸ್ ಶುರು ಮಾಡೋದಾಗ ನಮ್ಗೆ ಒಂದು ಹೇಳ್ತಾ ಇದ್ದು, ಬೆಳಗ್ಗೆ ಹೋಗಿ ಕೋರ್ಟಲ್ಲಿ ಕೂತ್ರೆ ನೀ ಕೇಸ್ ಇರ್ಲಿ ಮುಗಿದೇ ಇರ್ಲಿ, ಸಾಯಂಕಾಲ ಜಡ್ಜ್ ಎದ್ದು ಬಾಗಿಲಿಂದ ಹೊರಗಡೆ ಹೋಗಲಿವರೆಗೂ ಕೋರ್ಟ್ ಹಾಲಲ್ಲಿ ಇರ್ಬೇಕು. ಇದ್ವೆ ಕಲೀಲಿಕ್ಕಾಗ್ತದೆ ಕೇಸ್ಗಳು. ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತೇನೆ 2:30ಗೆ, ಕೊಡಿ ಮೆಮೊ, ಅದ್ರಲ್ಲಿ ಅರ್ಜೆನ್ಸಿ ತೋರಿಸ್ಬೇಕು. ಎಸ್, ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತಾ ಇದು? ನನ್ನೆದೇ ಬಂದಿದೆ ಮೊನ್ನೆ. ಯಾಕ್ರಿ ನಾವೇನೋ ಒಂದು ಗೌರವ ಕೊಟ್ಟು ಕೇಳ್ತೀವಪ್ಪ ವಕೀಲರನ್ನ. ಅಂತಲ್ಲಿ ಬಂದಿತ್ತ, ತನಗೆ ಬಂದು ನಿಲ್ತಾನೆ ಗೊತ್ತಾಗ್ತದೆ ಸಾಮಾನ್ಯ ಒಂದು ಇಂಟ್ಯೂಷನ್, ಇದು ಬಂದಾಗಿದೆ ಮ್ಯಾಟ್ರು. Request of the learned counsel for the appellant as a final last opportunity, 10 days time as period is granted. Yes.
Other matters, seal number 4. To the B, case Timaya for a Kevatar R1.
Again, when counsel for the appellant has filed the memo. Withdrawal of withdrawal of appeal as having become effectual. In view of the memo supporting submission, the appeal stands dismissed. Infraction.
Seal number 31, Sri R.V. Sadashivappa, Sri Sidmalappa PM for Kevatar respondent.
The matter could not be proceeded.
Seal number 37. Prashantu UT.
Lord's order dated judgment and decree dated 21/4/2021 passed in OS number 751/17 is under challenge before this on court, please. Lords, the appellants had sought for declaration saying that first appellant is the wife of late Ram Rao and second appellant is the daughter of my lord's late Ram Rao, please. Now, my lords, it is the contention of this appellant that my lords, first appellant has got married to late Ram Rao in the year on 24/5/2001, please. Pursuant to marriage, my lords, the second appellant has been born. And my lords, on 6/7/2014, Ram Rao, my lords, who was working in railways, Department of Railways, my lords, as a pointsman, demised, leaving behind, my lords, these appellants to succeed to his estate, including, my lords, the death benefits. That is what the contention of these appellants is. Now, based on that, my lords, they made an application, my lords, seeking before respond number 1 to 3, seeking for, my lords, death benefits and, my lords, employment on compassionate ground. Respondent number 1 to 3, my lords, issued a letter dated 20/2/2015, contending, my lords, since the fifth respondent is also claiming as wife of late Ram Rao, therefore, kindly bring some declaratory order to know the legal status of the parties. This letter has been issued to both first appellant as well as fifth respondent, please. Now, my lords, with these facts, the appellants, my lords, sought for declaratory order from the trial court. My lords, fifth respondent who came on record, she contended that she has got married to late Ram Rao in the year 1982 and has begotten 3 children.
When was plaintiff's marriage with the Ramarao?
24/5/2001, my lords, please. As on the date, my lords, to be frank with your lordship, please. So far as marriage of my lords fifth respondent with late Ramrao is concerned, my lords, it is unknown to anyone. In fact, plaintiff, my lords, has adduced evidence and has got marked as many as P1 to P32 documents, please. As many as 32 documents. However, my lords, so far as defendant is concerned, my lords, and in addition to that, my lords, PW2 to 5 have been examined. 4 witnesses.
Your suit came to be dismissed.
Now, my lords, kindly turn to para 51 of this judgment, my lords, please. In fact, trial court also admits that the witnesses say that this first appellant is the wife. May I just draw attention of your lordship argument on para 51 of the judgment, my lords, please. May I read it, my lords? May I, my lords?
Yes.
PW4 was working as station manager in Yeshwanthpur Railway Department and he know the husband of the plaintiff, Ramrao, and he was working as pointsman. Ramrao married Srimati Manubai and she got a daughter by name Kumari Lakshmibai. That is second appellant, please. In his cross-examination, he has stated that he has not seen the service register of deceased Ramrao, but he has seen the fifth defendant. He has further stated that he knew the deceased Ramrao and he was under his control. On perusal of oral evidence of PW2 to 4, they have deposed that plaintiff number 1, that is appellant number 1, is the wife of the deceased Ramrao, but they do not know whether the defendant number 5 is legally wedded wife of Ramrao or not. Now, this is what the deposition of collective deposition of PW4 to 5 is all about. Now, assuming for a while, my lords, that first appellant is not a legally wedded wife, let us assume. So far as second appellant is concerned, my lords, in view of section 16(3) of Hindu Marriage Act, she is very much entitled to, my lords, death benefits. She is considered as very much a legitimate child. That has been kindly perused, my lords, para 59 of the judgment, please. Now, since because, my lords, first appellant has failed to prove that she is legally wedded wife, therefore, my lords, and in fact, my lords, issue has been framed. As many as 9 issues have been framed. Second issue is regarding, my lords, legitimacy of a child. May I read, my lords, please? Paragraph 59. The plaintiffs have failed to prove that the first plaintiff is legally wedded wife of Ramrao. Therefore, the plaintiffs are not entitled for receiving their service benefit accrued upon the death of Ramrao in Southwestern Railways as well as his terminal benefits, including the job on compassionate note and insurance policy benefits.
Notice paper. PCR. Yes.
Still number 39, Shri G.R. Lakshmipati.
For partition. Engagement. Plaintiff is daughter of the first defendant and sister of all the other defendants. The contentions of the defendants 3 and 5 for the contesting defendants. They contended that item number 1 is their self-acquired property. Item number schedule A. Schedule B is which is the matter which is which has been purchased in the name of father after it was mortgaged in favor of some
Emergent.
from there they have released it by paying.
Emergent notice. Yes.
Other arguments? Yes. Further arguments, serial number 41, Srimati PV Nidhishri, Sri T. Sheshagiri Rao for R3.
Section 67. No man's property is government property.
Yes, ma'am.
Yes.
Section 67. Referable to Bikara part of the 21B ನಲ್ಲಿ ಬರುವಂತ ಪ್ರಾಪರ್ಟಿಗೆ the relevant provision is 67. What 67 says is the part of the property belonging to the government. Government shall be the owner of the property. Decides on the main land and remains as a separate land belonging to the government. In that background, I will just read 67. Public roads and all lands which are not the etc. And all lands which are not the property of others belong to the government. All public roads, streets, lanes, path, bridges, ditches, dikes, and fences are besides the same, the bed of the sea and harbors, creeks below high water mark and river streams, nalas, lakes and tanks, and all canals and water courses, and all standing flowing waters, and all lands wherever situated which are not the property of the individuals are of aggregate of persons legally capable of holding property, and except in so far as any right of such person may be established in or over the same, and except may be otherwise provided in any law for the time being in force, and hereby declared to be with all rights over the same are operating thereto the property of the state government. Now, suppose if there is a Karab land, reserved Karab land, the government wanted to change the nature of the land. Suppose if there is a road, they want to convert it into a garden. Necessarily, they have to hold proceedings under section 68. Several procedures request to be complied. The deputy commissioner has to hold proceedings under section 68. The relevant rule under the land revenue rule says 94, 95, 96.
The reading of section 67 doesn't give an impression that it applies
My
to big Karab land, right?
Your Lordship may kindly say, please, madam.
The reading of section 67 doesn't give an impression that it applies to Karab land under section 21(2)(b), right?
Now, I will take my lord to 21B, rule 21B. Land revenue rules. (21)(2)(b), my lord.
Yes.
That which is not assessed because of it is reserved or assigned for public purpose. It is occupied by a road or recognized footpath or by a tank or stream used by persons other than the holders of the irrigation, drinking or domestic purpose, used burial ground, cremation ground, assigned for village potteries, etc. Now, court may feel the temple is not in. Temple by definition is a public property. By itself is a public property. So taking note of the same in the award proceedings, the land action officer dissected that portion of the property while holding acquisition proceedings. So it is not the case of the other side also that it is not a public property. However, compensation has been given and it has been sold to us. That is the contention. A public property vests with the government. Even the government wanted to change the use of the same. They have to fall back to several procedures contemplated under Section 68 of the Land Revenue Act, read with 94, 95 and 96 of it. Finally notification ಆಗಬೇಕು. Section 68(5) of the Land Revenue Act. Then they have to travel to
Yes.
Then they have to travel to Rule 94. Rule 94 ನಲ್ಲಿ ತಿರ್ಗಾ proceedings ಆಗಬೇಕು. 95 ನಲ್ಲಿ ಆಗಬೇಕು. 96 ಅಲ್ಲಿ ಆಗಬೇಕು. Then they have to come back again to 68(6) to change the use of the land from one purpose to other purpose. So therefore, here is a government property. It has been used as a temple. Every person has a fundamental right to use the temple for worshipping it. Now they have taken a contention. It is with us. Now I humbly request my lord to come down to exhibit P3. P3 is the relinquishment deeds. It is dated 18/4/1994.
Yes.
Para number 2.
Yes.
Whereas the Bangalore Development Authority may not got it.
Yes.
Authority Bangalore sanctioned the formation of private layout in survey number so and so. Sir, 24/2, 34/1, 34/3, 35/1, 35/2, 35/3, 36/1 and 36/2 of Kacharpalli village, Bangalore North Taluk, Bangalore in an area of 14 acres, 22 guntas. White BDA resolution number so and so. That the demands of the BDA, such supervision charges, installation of lights, water and underground sewerage and chill carpeting of road have been fully paid. That the society having completed the layout work as per the orders of sanction by the laying road, drains, circles, cultivators, civil amenities, culverts, civil amenities more fully described in the schedule and has been made out. This deed in favor of the BDA, free of cost, requesting and authorizing them to maintain and develop all aspects of the aforesaid area for the benefit of the society, colony and the neighboring area for the larger interest of the greater Bangalore. The society having relinquished their right, handed over the above said areas except buildings constructed by such multi-purpose hall, kindergarten, school, shopping combined banking facility to the BDA itself in witness whereof. So therefore, they did not retain other than the except area contained in the. So therefore, temple has not been retained by them. Temple also goes along with the relinquished deed to the local authority. Then it becomes a public property. Schedule. This is the area retained by them. Rest of the area they handed over. In view of exhibit P3, temple is not in their custody.
One minute. Areas that are handed over are not the only those areas which are mentioned in first paragraph clause 3.
Yes.
And which is described in the schedule.
Yes.
Right.
Your Lordship, can you say what is retained by them has been indicated?
No, no. What is handed over them has been indicated.
Yes.
Not what is retained.
Yes, madam.
So what is handed over to them has been indicated in para 3 and in the schedule.
Yes.
It does not include temple.
Yes. The thing is, what is
handed over to them has been indicated. It does not include a temple.
But the sentence shows what has been retained by them. What has been retained by them has been indicated.
What has been given to them has been expressly, specifically, clearly indicated, and it is further confirmed, stating that that has been more fully explained in the schedule.
Yes.
Therefore, what is given is important. It is a relinquishment deed,
yes.
Not retaining deed. What is the deed? What I have relinquished. It is not that what I have retained. So when it says what I have relinquished, it says this is this, which are more fully described in the schedule I have relinquished.
Yes.
Then we have to give attention, concentration to that what has been relinquished.
That portion also has to be taken note of. That portion also requires consideration at the hands of the son of God. Now, this area being a worshipping place, anybody can claim an injunctive right or a superior right against others. Place of worship. Yes. A suit for injunction based on title, based on possession. These are the rules. Give is a right for a person to approach it. When the documents do not speak of, they are in exclusive possession of the property. This was delivered to them. the possession cannot be inferred. So far as title is concerned, this being a Kharab land, I believe it was not handed over to, prior to the acquisition, some award proceedings has taken place. Nobody can take the Kharab portion of the land, which is a government land. So it is difficult to infer. This was also sold to it. If really it was sold, certain procedure requires to be contemplated of the Land Revenue Act and Land Revenue Acts was to be followed. In the absence of all these things, I cannot be deprived. We should not be deprived of right of worship in the temple. Temple definition I have placed it. It is not
Probably, Mr. Counsel, both of you repeatedly repeating the limited scope of the suit as a suit for bare injunction.
Yes.
But attempting to widen the scope of the suit from different various angle, whichever suits both sides to your convenience. Admittedly, the process of acquisition of the land is not in dispute in this suit.
Noted.
In the guise of permanent injunction or denying the alleged title of the plaintiff or the matter, probably subject to the submission which both of you make, the court cannot venture into digging the process of the acquisition. We have only to see, as on the date of the institution of the suit, whether the plaintiff was in lawful possession of the property. Whether that possession can be treated at par with the possession of an individual's property, since the property is said to be involving a temple for public use. Therefore, with respect to a temple for public use, what is the concept of possession? What are the rights of a person who claims his alleged right over the land upon which the temple is established? Or the only point.
That is the only point.
Except mentioning, despite this court's repeated request to learned counsel from both sides, as to what is possession in this angle, in this particular suit, both of you are taking me to different shores, different streams, different areas without answering my question.
Lakshmi kindly say, nobody is having superior right, exclusive right. This is a suit claiming exclusive right over the property.
This next point will come to that.
Yes.
Tell me what is possession in the context of this case. Land is mine.
Yes.
Temple is for public use.
See,
what is the possession and whose possession?
You may be the owner of the property, but you cannot restrain me from placing the worshipping it. She is not the owner. The plaintiff is not the owner in this case. No ownership has been transferred to them also. Merely acquiring, while acquiring land action officer on the 550 ರೂಪಾಯಿನ ತಹಸೀಲ್ದಾರ್ ಅಕೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ ತಕ್ಷಣ he has not taken whatever right existed earlier continues later also. It is a place of worship.
Which is that right that was existing earlier for a general public? Right to worship.
Right to worship.
Whether that right to worship has been curtailed.
Your Lordship, suppose if the court decreased the suit with respect to the prayer and the averments contained in the plaint, it amounts to restricting the general public from worshipping it. Gate ಹಾಕ್ಬಿಡ್ತಾರೆ. ಒಂದು ಗೇಟ್ ಹಾಕಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಬಂದ್ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ಅವ್ರ ಗೇಟ್ ಅದು ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ
ಇರ್ಬೋದು. Your Lordship, I kindly say, they surrendered all the roads and everything they have surrendered. They cannot prevent the general public from worshipping it. ನಮಗೆ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಒಳಗಡೆ ಬರುತ್ತೆ, ನೀವು ಬರಬೇಡಿ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಆಗೋದೇ ಇಲ್ಲ. It is a place of worship. This has been practiced more than 100 years as on the date of acquisition.
Their suit.
Yes, madam.
If they are preventing, you get a separate cause of action. See, for the relief of a permanent injunction or a mandatory injunction to break open the lock alleged to have been put to the gate or to dismantle the gate. That is not the case here.
Yes.
The case is theirs.
They say that in the guise of worshipping,
ಅದನ್ನ ಏನ್ ಹೇಳಿಲ್ಲ, ಇನ್ ದ ಗೈಸ್ ಆಫ್ ವರ್ಷಿಪಿಂಗ್ ಅಂತ ಹೇಳೇ ಇಲ್ಲ. ಇಟ್ ಇಸ್ ಅವರ್ ಪ್ರಾಪರ್ಟಿ, ಡೋಂಟ್ ಎಂಟರ್. ದಟ್ ಈಸ್ ಪರ್ಪೋರ್ಟ್ ಆಫ್ ಪ್ಯಾರಾ ನಂಬರ್ 16 ಅಂಡ್ ಪ್ಯಾರಾ ನಂಬರ್ 7 ಆಫ್ ದಿ ಪ್ಲೇಂಟ್.
ಅದನ್ನ ಅವರು ಸರಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ, ನೀವು ಸರಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ. ಕೇಸು ಸುಲಭದಲ್ಲಿರೋದನ್ನ ಸುಲಭವಾಗಿ ಬಗೆಹರಿಲಿಕ್ಕೆ ಅದೇನ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ತಾರೋ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ತಾರೋ ಮಾಡಿ ಅಂದ್ರೆ ಅವ್ರು ಮಾಡಲ್ಲ. ಅವ್ರು ಮಾಡದೇ ಇರೋದ್ರಿಂದ ನೀವು ಅವ್ರ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ನೀವು ಅದಕ್ಕೆ ನೇತಾಡ್ತೀರಿ. ಇಷ್ಟೇ ಆಗ್ತದೆ. ಇಬ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ತಯಾರಿದ್ದೀರಿ, ಇಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗೋದು ಇಬ್ರಿಗೂ ಬೇಡ. ಪಾಯಿಂಟ್ ಅಷ್ಟೇ, ಪಾಯಿಂಟ್ ಅಷ್ಟೇ. ಇಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗೋದು ಇಬ್ರಿಗೂ ಬೇಡ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು. ನೀವು ಇನ್ನೂ 20 ವರ್ಷ ಈ ಕೇಸ್ ಇರಬೇಕು. ಇಬ್ರು ಅದನ್ನೇ ಬಯಸೋದಾದ್ರೆ ಕೋರ್ಟ್ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ? ರಿಪೀಟೆಡ್ಲಿ ಶಿ ವಾಸ್ ಟೆಲ್ಲಿಂಗ್, ಹರ್ ಓಪನಿಂಗ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ವಾಸ್ ದಟ್ ವಿ ನೆವರ್ ರಿಸ್ಟ್ರೈನ್ ಎನಿ ಪಬ್ಲಿಕ್, ಎನಿ ಸ್ಟ್ರೇಂಜರ್, any public from worshipping Lord Muneshwara. We have never prevented them, we will never prevent them. ಬಾಯಲ್ಲಿ ಹೇಳಿಬಿಟ್ರೆ ಉಳಿದಂತವ್ರು ಏನು ಮೆಟೀರಿಯಲ್ ತೋರಿಸ್ತಿಲ್ಲ. ನೀವು ಅವ್ರು ನಮ್ಮನ್ನ ಬಿಡ್ತಾ ಇಲ್ಲ, ಗೇಟಿಗೆ ಬೀಗ ಹಾಕ್ತಿದ್ದೀರಿ ಅಂತಿರೋ ಹೊತ್ತು ಅವರು ನಾವು ಯಾವುದೇ ವರ್ಷಿಪ್ಪರ್ನ ನಾವು ವರ್ಷಿಪ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ತೊಂದರೆ ಕೊಡಲ್ಲ ಅಂತ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ತಾ ಇರೋದನ್ನ ನೀವು ಗಮನಿಸ್ತಿಲ್ಲ. ನಿಮಗೆ ಬೇಕಾಗಿರೋದು ಅಲ್ಲಿ ಈಗ ದೇವ್ರ ಪೂಜೆ ಇಲ್ಲ, ನಿಮಗೆ ಬೇಕಾಗಿರೋದು ದೇವ್ರ ಹುಂಡಿ, ದೇವ್ರ ಮೇಲೆ ಒಂದು ಕಿರೀಟ, ಅದ್ರ ಮೇಲೆ ನೀವು ಮಂಗಳಾರತಿ ಮಾಡಿ ನೀವು ಅದ್ರದ್ದು ಧರ್ಮದರ್ಶಿಗಳು ಅಥವಾ ಆಡಳಿತಗಾರರು ಅಂತ ಹಾಕೊಂಡು ಆ ದೇವಸ್ಥಾನದ ಹೆಸರಿನಲ್ಲಿ ನೀವು ಒಂದು ಹಕ್ಕು ಸ್ಥಾಪಿಸ್ಬೇಕು. ಅದು ನಿಮ್ಮ ಉದ್ದೇಶ. ಅವರಿಗೆ ನಮ್ಮ ಸೊಸೈಟಿಲಿರೋ ದೇವಸ್ಥಾನದಲ್ಲಿ ಸುಮ್ಮನೆ ಬಂದು ಹೋಗೋದ್ರ ಬದಲು ಇವ್ರು ಇನ್ನೇನೋ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತಾರೆ, ಇನ್ನೇನೋ ಕಟ್ಟಡ ಕಟ್ತಾರೆ, ಇದು ನಮ್ಮ ಸೊಸೈಟಿ, ಇದು ನಮ್ ದೇವಸ್ಥಾನ ಅಂತ ಹೇಳಿ ಅವರು ಆ ದೇವಸ್ಥಾನ ರೈಟ್ ನಮಗೆ ಬಾಗಿಲು ನಾವೇ ಹಾಕ್ತಿವಿ, ಬೀಗನು ನಾವೇ ಹಾಕ್ತಿವಿ, ಗೇಟಿಗೂ ಬೀಗನ ನಾವೇ ಹಾಕ್ತಿದೀವಿ ಅಂತಾರೆ. ಇಬ್ಬರಲ್ಲೂ ಟು ಸಮ್ ಎಕ್ಸ್ಟೆಂಟ್ ಎಕ್ಸ್ಟ್ರೀಮಿಟಿ ಇದೆ. ಅದನ್ನು ಒಪ್ಕೊಳ್ಳಿಕ್ಕೆ ಇಬ್ರು ತಯಾರಿಲ್ಲ. ದೇವ್ರ ಸಮಸ್ಯೆನ ನೀವು ದೇವ್ರನ್ನು ಜೀವಂತ ಇಟ್ಟು ಜ್ವಲಂತ ಇಟ್ಟು ಸಮಸ್ಯೆನು ದೇವರಲ್ಲಿವರೆಗೂ ಇರ್ಲಿಕ್ಕೆ ನೀವು ಇಬ್ರು ಬಯಸ್ತೀರಿ. ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ? ದೇವ್ರ ಬುದ್ಧಿ ಕೊಟ್ಟಂಗ ನಾನ್ ಬರೀಬೇಕು. ಸುಲಭದಲ್ಲಿ ಹೇಳ್ತಿದ್ದಾರೆ, ಸುಲಭದಲ್ಲಿ ಆಗ್ತದೆ. ನಿಮ್ಮ ಇಂಟ್ರೆಸ್ಟ್ ಇರೋದು ದೇವ್ರ ಪೂಜೆ ಮಾಡ್ಲಿಕ್ಕೆ, ದರ್ಶನ ಮಾಡ್ಲಿಕ್ಕೆ. ಅದಕ್ಕೆ ಅವ್ರು ನಾವು ಯಾವತ್ತೂ ಅಡೆತಡೆ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಅಡೆತಡೆ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಎರಡೇ ಸೆಂಟೆನ್ಸಿನದರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ಮುಗಿದು ಹೋಗ್ತದೆ. ನಾವು ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಕೂಡ ಯಾವುದೇ ಭಕ್ತಾದಿಗಳನ್ನ ದೇವರನ್ನು ಪೂಜಾ ಪುನಸ್ಕಾರ ಬಂದು ವರ್ಷಿಪ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ನಾವು ತೊಂದರೆ ಕೊಡಲ್ಲ. ಸರಿ, ನಾವು ಕೂಡ ಕೇವಲ ದೇವರ ದರ್ಶನ ಮತ್ತು ವರ್ಷಿಪ್ಪನ್ನು ಹೊರತುಪಡಿಸಿ, ದೇವರ ಪ್ರಾರ್ಥನೆ ಮತ್ತು ದರ್ಶನದ ಹೊರತುಪಡಿಸಿ ನಾವು ಯಾವುದೇ ಹಕ್ಕುಗಳನ್ನು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಸ್ಥಾಪಿಸಲ್ಲ. ಮುಗಿದೋಯ್ತು. ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಒಂದು ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಆಫ್ ವರ್ಷಿಪ್ ಅಂತ ಏನಿದೆ ಅದನ್ನ ಯಾರು ಅದ್ರದ್ದು ಉಸ್ತುವಾರಿ ನೋಡ್ಕೊಳ್ಬೇಕು. ಅದನ್ನ ನೀವು ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಫೋರಂ ಬೇರೆದಿದೆ ಬೇಕಾದಷ್ಟು, ಅಲ್ಲಿ ನೀವು ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಬಹುದು. ದಟ್ ಇಸ್ ದ ಮೋಸ್ಟ್ ಅಕ್ಯುರೇಟ್ ಪ್ರೊಸೀಜರ್. ಅದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಇಬ್ರು ತಯಾರಿಲ್ಲ. 25 ರೂಪಾಯಿ ಕೋರ್ಟ್ ಫೀನಲ್ಲಿ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ನಲ್ಲಿಯೇ ಇನ್ನು 20 ವರ್ಷ ಈ ಕೇಸ್ ಇರಬೇಕು. ಇರ್ಲಿ, court won't hesitate to make observation on all this point.
The temple is in a dilapidated condition, which also requires to be regenerated. Whether they do it or we do it or some general public do it, no matter much. Upliftment of the temple is also involved in the matter. They are not allowing. They want the temple should be demolished.
No, they are asking, who are you to uplift the temple? What authority you have got? You worship, no problem. But what authority you have got to say that you have got every right to uplift the temple? ಈ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು ಅದೇ. ನಾನು ಹೇಳಿದೆ ಅಲ್ವಾ, ಅಪ್ಲಿಫ್ಟ್ಮೆಂಟ್ ಆಫ್ ಟೆಂಪಲ್ ಅಂದ ಅರ್ಥದಲ್ಲಿ ಆ ದೇವಸ್ಥಾನದ ಕುರಿತು ಹಕ್ಕು ಸ್ಥಾಪನೆಗೆ ಹೊರಟಿದ್ದೀರಿ ಪರಸ್ಪರವಾಗಿ ಅಷ್ಟೇ. ನಾಳೆ ಮುನೇಶ್ವರ ಏನಾಗ್ತಾನೆ, ದೇವರೇ ಓಡಿ ಹೋದ್ರು ನಿಮಗೂ ಮುಖ್ಯ ಅಲ್ಲ. ಅಲ್ಲಿ ಬೋರ್ಡು, ಮ್ಯಾನೇಜ್ಮೆಂಟ್, ಬೀಗದ ಕೈಗಳು ಬರಬೇಕು. ಆಮೇಲೆ ಅದಕ್ಕೊಂದು ಜಾತ್ರೆ ನಾವೇ ನಡೆಸೋದು, ನಾವೇ ಅದಕ್ಕೆಲ್ಲ ಮುಖಂಡರು ಮುಖ್ಯಸ್ಥರು ಅಂತ ಆಗ್ಬೇಕು. ನಾವು ಮುಖಂಡರು, ನಾವು ಮುಖ್ಯಸ್ಥರು, ನಮ್ಮ ಮನೋಭಾವನೆ ನಮ್ಮ ಸಾರ್ವಜನಿಕವಾಗಿ ನಮ್ಮ ಜನರ ಮೈಂಡ್ ಇಂದ ಹೋಗದ ಹೊರತು ನಮ್ಮಲ್ಲಿ ಭಾರತದಲ್ಲಿ ಹಿಂದೂ ದೇವತೆಗಳಿಗೆ ಮುಕ್ತಿ ಇಲ್ಲ. ದೇವರು ನಮಗೆ ಮುಕ್ತಿ ಕೊಡೋದಲ್ಲ, ನಾವು ದೇವರಿಗೆ ಮುಕ್ತಿ ಕೊಡುವ ಕಾಲ ಬಂದಿದೆ ಈಗ. ಯಾವುದೇ ಲಿಟಿಗೇಷನ್ ತಗೊಳ್ಳಿ, ಯಾವುದೇ ತಗೊಳ್ಳಿ, ಕಾಶಿ ವಿಶ್ವನಾಥ ತಗೊಳ್ಳಿ, ಮಥುರಾ ತಗೊಳ್ಳಿ, ಬಾಬ್ರಿ ತಗೊಳ್ಳಿ, ಮುನೇಶ್ವರ ತಗೊಳ್ಳಿ, ನಿಮ್ಮಲ್ಲಿ ದೇವರಿಗೆ ಮುಕ್ತಿ ಕೊಡೋದು ಈಗ ನ್ಯಾಯಾಧೀಶರ ಜವಾಬ್ದಾರಿಯಾಗಿದೆ. ತುರಂತ ಸುಲಭದಲ್ಲಿ ಆಗಂತದ್ರಿ, ಸುಲಭದಲ್ಲಿ ಆಗಂತ
ಮಾಡ್ಕೋಬಹುದು. ಅವ್ರು ಮಾಡ್ಕೊಂತಾ ಇಲ್ಲ. ದೇವ್ರು ಏನೋ ಒಂದು ಕರೆದು ಒಂದು ಸಮಿತಿ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ರ.
ಆ ಸಮಿತಿನ ನೀವು ಸಮಿತಿಯನ್ನ ಪದ ಯೂಸ್ ಮಾಡಿದ ಕೂಡಲೇ ಅದು ಡಿಸ್ಪ್ಯೂಟ್ ಬರುತ್ತೆ. ಸಮಿತಿಯನ್ನ ಪದ ಬಂದ ಕೂಡಲೇ ಅದು ಡಿಸ್ಪ್ಯೂಟ್ ಬರ್ತದೆ. ನಿಮಗೆ ಬೇಕಾಗಿರೋದು ಸಮಿತಿ. ಅವರಿಗೆ ಬೇಕಾಗಿರೋದು ಈಗ ಸಮಿತಿಯಲ್ಲಿ ಅವ್ರ ಗೇಟೆಡ್ ಕಮ್ಯುನಿಟಿ ಒಳಗೆ ಏನಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅದು ಹಂಗೆ ಹೋಗ್ಬೇಕು,
ಹಾಗೆ ಉಳ್ಕೋಬೇಕು.
ಹಾಗೆ ಉಳ್ಕೊಳ್ಬೇಕು ಅಷ್ಟೇ, ಅದಷ್ಟೇ.
In the light of the prayer and government, could the court can grant an order? ಏನು ಮಾಡೋದು ಅಷ್ಟೇ. Whether injunction order can be granted either against the defendant number 3 or against anybody being a place of worship, irrespective of the title dispute. Title dispute is not before the court. So therefore, one cannot restrain the other from worshipping it. So therefore, the prayer which they have sought, that cannot be considered and granted. It is not a family temple. It is a public temple.
ಯಾವ ಧರ್ಮ, ಯಾವ ದೇವಸ್ಥಾನಗಳು, ಯಾವ ಪ್ರಾರ್ಥನಾ ಸ್ಥಳಗಳು ಜನರಿಗೆ ಶಾಂತಿ ನೀಡಲಿಕ್ಕೆ, ಜನಗಳಿಗೆ ಒಳಿತನ್ನು ಮಾಡಲಿಕ್ಕೆ, ಜನರಲ್ಲಿ ಒಳ್ಳೆಯ ಆಲೋಚನೆಗಳನ್ನು ಹುಟ್ಟು ಹಾಕಲಿಕ್ಕೆ, ಅವರ ಜೀವನ ಕ್ರಮವನ್ನು ಸುಧಾರಿಸಲಿಕ್ಕೆ ಮಾಡಬೇಕು. ದುರಂತ ಅಂದ್ರೆ ಇತ್ತೀಚಿನ ವರ್ಷಗಳಲ್ಲಿ ಅಂತಹದೇ ದೇವರು, ಧರ್ಮ, ಪ್ರಾರ್ಥನಾ ಮಂದಿರ, ದೇವಸ್ಥಾನಗಳ ಹೆಸರಿನಲ್ಲಿ ಜನಗಳು ಅಶಾಂತಿಗಳನ್ನೇ ಹೆಚ್ಚು ಬೆಳೆಸ್ತಾ ಇದ್ದಾರೆ, ಅಶಾಂತಿಯನ್ನು ಮುಂದುವರಿಸ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. ದೇವರು, ದೇವರ ಧ್ವಜ, ದೇವರ ನಾಮ, ದೇವರ ಕಿರೀಟ, ದೇವರ ಸ್ಥಳ, ದೇವರ ಲಾಂಛನ, ದೇವರ ಜಾತಿ, ದೇವರಿಗೂ ಜಾತಿ ಕಟ್ತೇವೆ ನಾವು. ಅವುಗಳನ್ನೇ ಎದುರುಗಡೆಗೆ ಇಟ್ಕೊಂಡು ನಾವು ಹೊಡೆದಾಡ್ತೇವೆ, ಅದರಲ್ಲಿ ನಮ್ಮ ಬೇಳೆ ಬೇಯಿಸ್ಕೊಳ್ತೇವೆ. ಅದಕ್ಕೆ ನಾನೊಬ್ಬ ಅಧ್ಯಕ್ಷ, ನಾನೊಬ್ಬ ಧರ್ಮದರ್ಶಿ, ನಾನು ಮಂಡಳಿ, ನನ್ನ ಮುಖ್ಯಸ್ಥ, ಅದಕ್ಕೆ ನನಗಿಷ್ಟು ಗ್ರಾಂಟು, ನಾನು ಕಲ್ಯಾಣ ಮಂಟಪ ಕಟ್ಟಿಸ್ತೇನೆ, ಕಮ್ಯುನಿಟಿ ಹಾಲ್ ಕಟ್ಟಿಸ್ತೇನೆ, ಅದರಿಂದ ನಾನು, ನನ್ನ ವಂಶ, ಅದಕ್ಕೊಂದು ಆಮೇಲೆ ಒಂದು ಟ್ರಸ್ಟ್ ಅನ್ನೋದು ಬರುತ್ತೆ. ಮೂಲ ದೇವ್ರ ಹೆಸರು, ಯಾವ ದೇವ್ರು ನಮ್ಗೆ ಒಳ್ಳೆ ಬುದ್ಧಿ ಕೊಡ್ಬೇಕು ಆ ದೇವ್ರನ್ನ ನಾವು ನಮ್ಮ ದಾಳಕ್ಕೆ ಬಳಸ್ಕೊಳ್ತಿದ್ದೇವೆ. ಇದು ಸತ್ಯ. ಇಂತಹ ಏನಿದೆ ವಾದ ವಿವಾದಗಳು, ಇದನ್ನ ಆ ದೇವ್ರನ್ನ ನೆಪವಾಗಿ ಇಟ್ಕೊಂಡು ನಾವು ಸುಮ್ಮನೆ ಹೊಡೆದಾಡ್ತಾ ಹೋಗೋದ್ರ ಬದಲು ಏನಿದೆ, ನಿಮಗೆ ಬೇಕಾಗಿರೋದು ದರ್ಶನ, ಪೂಜೆ, ಅವರು ಅದಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿ ಕೊಡ್ತಾರೆ. ಸರಿ, ಆ ದೇವಸ್ಥಾನ ಕುಸಿದು ಬೀಳುತ್ತೆ, ಕುಸುವುದು ಬೀಳುವ ಸ್ಥಿತಿಯಲ್ಲಿ ಇದೆ. ಅದನ್ನ ಇಲ್ಲ ನಾನೇ ಕಟ್ಟೋದು, ನಾನಿದ್ರೆ ದೇವರು ಬದುಕ್ತಾನೆ, ನಾನೇ ದೇವರಿಗೆ ಒಂದು ಆಶ್ರಯ ಬೇರೆ ಯಾರು ಮಾಡುವ ಹಾಗಿಲ್ಲ, ಅವರದ್ದು ಸರಿಯಲ್ಲ. ಇಬ್ಬರು ಕೂತು ಇಂತಹ ಒಂದು ಸಂದರ್ಭದಲ್ಲಿ ಕಾನೂನು ಏನು ಹೇಳುತ್ತೆ? ಒಂದು ವಸತಿ ಸಂಕೀರ್ಣದ ಒಂದು ಪ್ರದೇಶದ ನಡುವೆ ಒಂದು ಸಾರ್ವಜನಿಕರ ಉಪಯೋಗಕ್ಕಾಗಿ ಅಥವಾ ದರ್ಶನಕ್ಕಾಗಿ ಇರ್ತಕ್ಕಂಥ ಒಂದು ದೇವಸ್ಥಾನ, ಅದು ಪುರಾತನವಾದ ದೇವಸ್ಥಾನ ಅನ್ನೋದು ನಿರ್ವಿವಾದವಾಗಿರುವಾಗ, ಅದು ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಗೆ ಬಹಳ ಹಿಂದಿನ ದಶಕಗಳಿಂದಲೂ ಅದು ಅಸ್ತಿತ್ವದಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳಿದಾಗ, ಅದನ್ನ ಯಾರು ಆ ದೇವಸ್ಥಾನದ ಜೀರ್ಣೋದ್ಧಾರವನ್ನು ಗಮನಿಸಬೇಕಾಗುತ್ತೆ. ಸರಿ, ಅದು ನೀವು ಅಲ್ಲ ಅವರು ಅಲ್ಲ ಅಂತಾದ್ರೆ, ನೀವು ಬರಬೇಕಾದ್ರೆ ದೇವಸ್ಥಾನ ಜೀರ್ಣೋದ್ಧಾರ ಸಮಿತಿ ಅಂತ ಮಾಡಿ ಸರ್ಕಾರಕ್ಕೆ ಹೇಳಿ, ಸ್ವಾಮಿ ದೇವಸ್ಥಾನ ನಿಂದು, ನೀವು ಇದನ್ನ ಇಂಪ್ರೂವ್ ಮಾಡ್ರಿ, ನಮಗನ ಅನುಕೂಲ ಆಗ್ತದೆ. ಹಾಗೆ ಹೇಳುವ ಬುದ್ಧಿ ಒಬ್ರಿಗಾದ್ರೂ ಇದೆಯಾ? ನಿಮ್ಮಿಬ್ಬರಲ್ಲಿ ಇಬ್ರಿಗೂ ಇಲ್ಲ. ಇಬ್ರಿಗೂ ಇರೋದು ನಾನು ಮಾತ್ರ ದೇವರಿಗೆ ವಸತಿ ಕಲ್ಪಿಸಿ, ನೆರಳು ಕಲ್ಪಿಸಿ, ದೇವರನ್ನ ಕ್ಷೇಮವಾಗಿ ಇಡ್ತೇನೆ.
ಈ ವಿಚಾರ ನಾನು ಮೊದಲನೇ ದಿವಸನಿಗೆ ದೇವ್ರ ಬಗ್ಗೆ ನಾವು ಜಗಳ ಕಾಯಬಾರ್ದು. either form a committee jointly by your people and our people. Otherwise, we will intimate the government. They will go for a declaration. 42 ನಲ್ಲಿ Endowment Act ಅಲ್ಲಿ once the intimation is given when there is a dispute with regard to the worship in place, they will notify it. They will declare it. Proceedings ಮಾಡಿ declare ಮಾಡಿ. They will take over the thing. That is all the thing. Either by mutual understanding or by force or compulsion. ಅದನ್ನ ನಾನು ನಮ್ಮ ಸ್ನೇಹಿತರಿಗೂ ಹೇಳಿದೆ. They have not shown any interest. I am the last person to destroy the situation. I don't want it. ಒಂದು ನೆಮ್ಮದಿ ಇದ್ದು ಏನೋ ಒಂದು ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ ಅದೇ ದೊಡ್ಡ ದೇವಸ್ಥಾನ ಕಟ್ಟಿ ಇವತ್ತೆಲ್ಲ ನಶಿಸಿ ಹೋಗ್ತಾ ಇದೆ. ಇದೆಲ್ಲ ಒಂದು 100 ವರ್ಷದ ದೇವಸ್ಥಾನ ಇದು. ಎಲ್ಲ ಮಳೆ ನೀರು ಬಂದ್ರೆ ಸುರಿತಾ ಇದೆ, ಯಾರು ರಿಪೇರಿ ಮಾಡ್ತಾರೆ? ಆ ನೀರೆಲ್ಲ ದೇವ್ರ ತರ ಬಿಡ್ತಾರೆ. ಮಾಡಿ, ಒಳ್ಳೇದು ಮಾಡಿ, ಯಾವ್ದಾದ್ರು ಒಳ್ಳೇದು ಮಾಡಿ, ನಾವು ಸಹಕಾರ ಕೊಡ್ತೀವಿ. ಜನರು ಫಂಡಿಂಗ್ಸ್ ಬೇಕಾದ್ರೆ ರೈಸ್ ಮಾಡಿ, ಇನ್ನೇನು ಸರ್ಕಾರ ಏನು ಕೊಡೋದಿಲ್ಲ, ಫಂಡಿಂಗ್ಸ್ ರೈಸ್ ಮಾಡಿ, ಒಂದು ಒಳ್ಳೇದು ಒಂದು ದೇವಸ್ಥಾನ ಕಟ್ಟಿ, ಒಂದು ಜನ ಕೂತ್ಕೊಂಡು ನಮಸ್ಕಾರ ಮಾಡ್ಬಿಟ್ಟು ಇವತ್ತು ನಾನು ಅದೇನೆ ಹೇಳ್ತೀನಿ, ಜನ ಕರಿ ನಮ್ಮವರೇ ಆಗ್ಬೇಕು, ಇವರೇ ಆಗ್ಬೇಕು ಅನ್ನೋದು ಬೇಡ. ಎಲ್ಲರೂ ಕಂಬೈನ್ಡ್ ಆಗಿ ಕೂತ್ಕೊಂಡು ಒಂದು ದೊಡ್ಡ ಆಲೋಚನೆ ಮಾಡಿ ಜೀರ್ಣೋದ್ಧಾರ ಮಾಡ್ತಾರೆ. ಇವತ್ತು ಈವನ್ ಟುಡೇ ಆಲ್ಸೋ ಐ ಆಮ್ ಮೇಕಿಂಗ್ ದಿ ಸೇಮ್ ಸಬ್ಮಿಷನ್. ಅವ್ರಿಗೊಂದು ದೊಡ್ಡ ಬುದ್ಧಿ ಬರ್ಬೇಕಷ್ಟೆ. ಈ ವ್ಯಾಜ್ಯ ಬೇಡ, ಜೀರ್ಣೋದ್ಧಾರ ಮಾಡೋಣ ದೇವಸ್ಥಾನ. ಯಾರಿಗೂ ಬೇಡಿ, ನಮ್ಗೇನ್ ಬೇಕಾಗಿಲ್ಲ. ನಾವು ಹೋದ್ರೆ ಒಂದು ಎಣ್ಣೆ, ಒಂದು ಬತ್ತಿ ಹಾಕ್ಬಿಟ್ಟು ಒಂದು ಹೂವು ಇಟ್ಬಿಟ್ಟು ಬರ್ತೀವಿ ಅಷ್ಟೇ, ಇನ್ನೇನು ಮಾಡೋದಿಲ್ಲ. ನಾವ್ ಅಲ್ಲಿಂದ ಏನು ತರಬೇಕಾದಿಲ್ಲ. ಇನ್ನು ಒಂದು ಡಬ್ಬ ಇಟ್ಟಿದ್ರೆ ಅದು ಜೀರ್ಣೋದ್ಧಾರಕ್ಕೆ ₹1 ಹಾಕ್ಬಿಟ್ಟು ಈಚೆಗೆ ಬರ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. ಯಾರು ಅದರಿಂದ ಏನು ಅಪೇಕ್ಷೆ ಪಡ್ತಾ ಇಲ್ಲ. ಆ ಜಾಗ ನಮ್ಗೆ ಯಾರಿಗೂ ಬೇಕಾಗೋದಿಲ್ಲ. ನಾವೇ ಕಮಿಟಿಲಿ ಇರ್ಬೇಕು, ಅವರೇ ಇರ್ಬೇಕು, ಏನು ಒಂದು ಜಾಯಿಂಟ್ ಕಮಿಟಿ ಮಾಡಿ ಜೀರ್ಣೋದ್ಧಾರ ಮಾಡ್ಲಿ, ಮುಗೀತು ಅಷ್ಟೇ. ಈ ವ್ಯಾಜ್ಯ ಮುಗಿದು ಹೋಗುತ್ತೆ. Under the circumstance whether the court can grant an order of injunction in the matters of this nature, that is all the question. We don't want ownership except worship. Devar kai mugidu balodu ashtene. We should not be restrained. If the prayer is granted, it is amounting to restraining us. That is all the case.
ನಮ್ಮ ಜನಗಳಲ್ಲಿ ತನ್ನ ಹೆಸರಿನಲ್ಲಿ ಈ ಪಾಟಿ ಕಲಹಗಳು, ಮನಸ್ತಾಪಗಳು, ವೈಮನಸ್ಸುಗಳು ಇದೆ ಅಂತ ದೇವರಿಗೆ ಕಂಡು ಬಂದ್ರೆ ಬಹುಶಃ ಅವನು ಎಲ್ಲಾ ದೇವಸ್ಥಾನಗಳಿಗೂ ಓಡಿದ್ರು. ಯಾವ್ದು ಬೇಡ, ಏನಾದ್ರು ಮಾಡಿ ಅಪ್ಪ. ದೇವಸ್ಥಾನದ ಬಗ್ಗೆ, ದೇವಸ್ಥಾನ ಜೀರ್ಣೋದ್ಧಾರ ಮಾಡ್ತೇವೆ ಅಂತ ನಾವು ತೋರಿಸುವ ಉತ್ಸುಕತೆಯಲ್ಲಿ 5% ನಾವು ಮಕ್ಕಳಿಗೆ ವಿದ್ಯೆ ಕೊಡ್ಸೋದ್ರಲ್ಲಿ ನೋಡ್ತೇವೆ, ಸಾರ್ವಜನಿಕರಿಗೆ ಒಂದು ಆರೋಗ್ಯ ಕೊಡ್ಸೋದ್ರಲ್ಲಿ ನಾವು ಮಾಡ್ತೇವೆ. ದೇವಸ್ಥಾನ ನಮ್ಮಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ, ಬೇಡ ದೇವಸ್ಥಾನ ಹಾಗಿಡಿ, ಅದ್ರದ್ದು ಆವರಣ ಪೂರ್ತಿ ನಾವೊಂದು ಚಿಕಿತ್ಸಾಲಯ ಮಾಡೋಣ, ಅಥವಾ ನಮ್ಮ ಊರಿನ ಅಥವಾ ನಮ್ಮ ಪ್ರದೇಶದ ಮಕ್ಕಳಿಗೆ ಒಂದು ಸ್ಕೂಲ್ ಮಾಡೋಣ. ಹುಂಡಿಗೆ ದುಡ್ಡು ಹಾಕಲ್ಲ ನಾವು, ಮಕ್ಕಳಿಗೆ ನಾವು ಎಜುಕೇಶನ್ಗೆ ಎಕ್ಸ್ಪೆನ್ಸ್ ಮಾಡ್ತೇವೆ. ಆ ಬಡ ಮಕ್ಕಳು ಯಾರಿದ್ದಾರೆ ಸುತ್ತಮುತ್ತ ಎಲ್ಲ, ಆ ಮಕ್ಕಳಿಗೆ ನಾವು ಪುಕ್ಕಟೆ ಮಧ್ಯಾಹ್ನದ ಬೇಕಾದ್ರೆ ಊಟ ಕೊಡೋಣಂತೆ, ಯೂನಿಫಾರ್ಮ್ ಕೊಡೋಣಂತೆ, ಪುಸ್ತಕ ಕೊಡೋಣಂತೆ. ಅದಕ್ಕೆ ನಾವು ಸಮಿತಿ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ, ಕಮಿಟಿ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ. ಯಾವ ದೇವರೇ ನಮ್ಗೆ ಒಳ್ಳೇದ್ ಮಾಡು ಅಂತೀವಿ, ಆ ದೇವರನ್ನ ರಕ್ಷಣೆ ಮಾಡ್ಲಿಕ್ಕೆ, ಆ ದೇವರಿಗೆ ನಾವು ಒಂದು ನೆಲೆ ಕಲ್ಪಿಸ್ಲಿಕ್ಕೆ ನಾವು ಹೊಡೆದಾಟ ಮಾಡ್ತೇವೆ, ಹೋರಾಟ ಮಾಡ್ತೇವೆ. ದುರಂತ ಹೀಗೆ ಇದೆ. ನಾನು ಮಾಡ್ತಿದ್ದೇನ್ರಿ, ಸುಮಾರು ಮಕ್ಕಳಿಗೆ ಮಿಡ್ ಡೇ ಮೀಲ್ಸ್ ಕೊಡ್ತಿದ್ದೇನೆ ನಾನು, ಹಂಡ್ರೆಡ್ಸ್ ಆಫ್ ಸ್ಟೂಡೆಂಟ್ಗೆ, ಲಾರ್ಜ್ ನಂಬರ್ ಆಫ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ನಾನು ಎಜುಕೇಶನ್ ಕೊಡಿಸ್ತಿದ್ದೇನೆ. ಅತ್ಯಂತ ಬಡತನ ಫ್ಯಾಮಿಲಿಯಿಂದ ಬಂದವ್ ನಾನು, ನನಗೆ ಗೊತ್ತು ಬಡತನ ಏನು, ವಿದ್ಯಾಭ್ಯಾಸದ ಮಹತ್ವ ಏನು. ನನಗೆ ಆಪ್ಷನ್ ಕೊಟ್ಟರೆ ಇಲ್ಲಿ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗ್ತೀಯಾ, ಪಕ್ಕದೊಂದು ಸ್ಕೂಲಿಗೆ ಹೋಗ್ತೀಯಾ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ದೇವ್ರನ್ನ ಮರಿತೇನೆ, ಸ್ಕೂಲಿಗೆ ಹೋಗ್ತೇನೆ, ಮಕ್ಕಳ ಜೊತೆ ಸಮಯ ಕಳೀತೇನೆ. ನಾನು ಆ ಮಕ್ಕಳ ದೇವ್ರನ್ನ ಕಾಣ್ತೇನೆ. ಸುತ್ತಿದ್ದೇನೆ, ಪ್ರಪಂಚದ ಎಷ್ಟೋ ಭಾಗ ನಾನು ಸುತ್ತಿದ್ದೇನೆ, ನೋಡಿದ್ದೇನೆ. ಏನಿಲ್ಲ, ನಾವು ನಮ್ಮ ನಂಬಿಕೆಗಳು, ನಮ್ಮ ಧರ್ಮ ಇತ್ಯಾದಿ ಅಂತೆಲ್ಲ ಹೇಳ್ತೇವಲ್ಲ, ಅದು ನಮಗೆ ನಾವೇ ಹಾಕೊಂಡಿರ್ತಕ್ಕಂಥ ಒಂದು ಚೌಕಟ್ಟು, ನಮ್ಮನ್ನು ಸನ್ಮಾರ್ಗದಲ್ಲಿ ನಡೆಸಲಿಕ್ಕೆ ಮಾತ್ರ. ಯಾತಕ್ಕಾಗಿ ನಾವು ಧರ್ಮವನ್ನು ನಮ್ಮ ಮೇಲೆ ಹೇರ್ಕೊಂಡಿದ್ದೇವೆ ಅಥವಾ ಧರ್ಮದೊಂದಿಗೆ ಗುರುತಿಸ್ಕೊಳ್ತೇವೆ, ಆ ಮೂಲ ಅಂಶನೇ ನಾವೀಗ ಮರೆತು ಬಿಟ್ಟಿದ್ದೇವೆ. ಅದನ್ನ ವ್ಯಾವಹಾರಿಕ, ವಾಣಿಜ್ಯಿಕ ಸ್ವಾರ್ಥಕ್ಕೆ ಮಾತ್ರ ನಾವು ಮಾಡಿ, ಅದರಂತೆ ನಾವು ಧರ್ಮವನ್ನು ನಮ್ಮ ಅಪೇಕ್ಷೆಗೆ ತಕ್ಕಂತೆ ನಾವು ಅದನ್ನ ವ್ಯಾಖ್ಯಾನಿಸಿ, ನಾನಿದ್ದರೆ ಧರ್ಮ, ನನ್ನಿಂದಲೇ ಧರ್ಮ,
ಅನ್ನುವ ರೀತಿಯಲ್ಲಿ ನಾವು ನಡೀತಿದ್ದೇವೆ. ಇದು ದುರಂತ. ಇದು ದುರಂತ.
ಕೆಲಸ ಮಾಡಿ ಬಟ್ ಐ ರಿಕ್ವೆಸ್ಟ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಈಗ ವ್ಯಾಜ್ಯ ನಡೆದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ ತೀರ್ಮಾನ ಮಾಡೋದು ರಾಮ್ ಜನ್ಮಭೂಮಿ ಎಲ್ಲ ನಿಂತೋಯ್ತು. ಕಮಿಟಿ ಮಾಡೋದು ತಮ್ಮ ನೇತೃತ್ವದಲ್ಲಿ ಒಂದು ಸಜೆಸ್ಟ್ ಮಾಡಿ ಯಾರು ಎಲೈಟ್ ಪೀಪಲ್ ಇರ್ತಾರೋ ಅವರನ್ನ ಕಮಿಟಿ ಮಾಡಿ ಕನ್ಸು ಎನಿ ಎಲೈಟ್ ಪೀಪಲ್
ಅದನ್ನ ಜಜ್ಮೆಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಜಡ್ಜ್ಮೆಂಟ್
ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
ಯಾರು ನನ್ನಿಂದಲೇ ದೇವರು ಅಂತ ಹೇಳಿ ನಿಮ್ ಇಬ್ಬರು ಪಕ್ಷಕಾರರಲ್ಲಿ ಇದ್ದಾರೆಯೋ ಅವರು ಸ್ವಲ್ಪ ತಿಳುವಳಿಕೆ ತಗೊಂಡ್ರೆ ಸಾಕಾಗ್ತದೆ. ಬೇಕಾಗಿರೋದು ಇದರಲ್ಲಿ ಕೆಲವೇ ವ್ಯಕ್ತಿಗಳ
ಹಿತಾಸಕ್ತಿ
ಭಕ್ತರಿಗೆ ಇಲ್ಲ. ಇದು ದೇವಸ್ಥಾನಕ್ಕೆ ಬರೋರು ನೀವು ಹೊರಗಿನಿಂದನೇ ಬರ್ರಿ, ಗೇಟ್ ಒಳಗಡೆಯಿಂದ ಇರ್ತಕ್ಕಂತಹ ಆ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಇರೋರು ಭಕ್ತರೇ ಬರ್ಲಿ, ಅವ್ರ್ಯಾರಿಗೂ ಈ ವ್ಯಾಜ್ಯದ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ವ್ಯಾಜ್ಯ ಬೇಡವೇ ಬೇಡ. ನೀವೇ ಹೇಳಿದಾಗ ಅವ್ರಿಗೆ ಬೇಕಾಗಿರೋದು ಹೋದಾಗ ದೇವರಿಗೆ ಒಂದು ದೀಪ ಹಚ್ಚಿದ ನಮಸ್ಕಾರ ಮಾಡಿದ್ವಿ ಬಂದ್ವಿ, ದೇವಸ್ಥಾನ ಇದೆಯಪ್ಪ ಚೆನ್ನಾಗಿದೆ, ಅಷ್ಟೇ ಸಾಕಾಗುತ್ತೆ ಅವ್ರಿಗೆ. ಅದಕ್ಕಿಂತ ಬೇರೆದು ಏನು ಬೇಡ. ದೇವರನ್ನ ನಾನು ನೋಡ್ಕೊಳ್ತೇನೆ ಅಂತ ಹೇಳಿ ಇಬ್ರು ಎದರ ಬದ್ರ ನಿಲ್ತಿರಲ್ಲ, ಅದು ದೇವ್ರು ಅವ್ರಿಗೆ ಒಳ್ಳೆ ಬುದ್ಧಿ ಕೊಡ್ಬೇಕು.
ನಾವು ಒಂದ್ಸಲಿ ಯೋಚನೆ ಮಾಡಿ, ದೀರ್ಘವಾಗಿ ಯೋಚನೆ ಮಾಡಿ, ಎನಿ ಎಲೈಟ್ ಪೀಪಲ್ ಇನ್ ದಟ್ ಲೊಕ್ಯಾಲಿಟಿ ದೇ ಮೇ ಬಿ ಆಸ್ಕ್ಡ್ ಟು ಮೇಂಟೈನ್ ಇಟ್. That can be done by the court also. ಅಲ್ಲಿಗೆ ಈ ವ್ಯಾಜ್ಯ ಪೂರೈಸುತ್ತೆ. ಒಂದು ದೇವಸ್ಥಾನನು ಜೀರ್ಣೋದ್ಧಾರನ ಸಿಗುತ್ತಿ. ನಮ್ಮವರೇ ಆಗ್ಬೇಕು ಅಂತ ನಾನೇನ್ ಕೇಳೋದಿಲ್ಲ. ಯಾರು ವಿದ್ಯಾವಂತರು ಇರ್ತಾರೋ, ಬುದ್ಧಿವಂತರು ಇರ್ತಾರೋ, ದೈವಾಂಶ ಇರ್ತಾರೋ ಅವ್ರನ್ನ ಮಾಡೋದ್ರ ಬಗ್ಗೆ.
ಅದು ಮತ್ತೊಂದು ವ್ಯಾಜ್ಯಕ್ಕೆ, ವಿವಾದಕ್ಕೆ ಕಾರಣ ಆಗ್ತದೆ. ಅವಾಗ ನೀವು ಏನ್ ಹೇಳಿದ್ರಿ, ನಾವು ಭಕ್ತರು ನೀವು ಭಕ್ತರು, ಅದೊಂದು ಪ್ಲೇಸ್ ಆಫ್ ಪಬ್ಲಿಕ್ ವರ್ಷಿಪ್. ಆ ದೇವಸ್ಥಾನ ಜೀರ್ಣೋದ್ಧಾರ ಆಗ್ಬೇಕು, 3 ಅಂತಸ್ತಿನ ದೊಡ್ಡ ಬೃಹತ್ ದೇವಾಲಯ ಬರಬೇಕು, ಅದ್ರ ಮೇಲೆ 108 ಮೆಟ್ಟಿಲುಗಳದ್ದು ಬಂದು ಅದ್ರ ಮೇಲೆ ಕಲಶ ಬರಬೇಕು, ನಿಂತಿರೋ ವಿಗ್ರಹ ಬರಬೇಕು, ಕೂತಿರೋ ವಿಗ್ರಹ ಬರಬೇಕು. ಅದೆಲ್ಲದನ್ನು ನೀವು ಭಕ್ತರು ಎರಡೂ ಕಡೆಯವರು ಯೋಚನೆ ಮಾಡೋದನ್ನ ಬಿಟ್ಬಿಡಿ. ದೇವಸ್ಥಾನ ಬೀಳುವ ಸ್ಥಿತಿಯಲ್ಲಿ ಇದೆ, ಅದು ದೇವಸ್ಥಾನ ಪಬ್ಲಿಕ್ ಯೂಸ್. ಆ ಭೂಮಿ ಕೆಳಗಡೆ ತಮ್ಮದು ಅಂತಾರೆ. ಹಾಗಿರ್ಬೇಕಾದ್ರೆ ದೇವಸ್ಥಾನ ಮೇಲಿರ್ತಕ್ಕಂಥ ದೇವಸ್ಥಾನ ಪಬ್ಲಿಕ್ ಯೂಸ್ ಅಂತ ಇರೋದ್ರಿಂದ ಆ ಪಬ್ಲಿಕ್ ಯೂಸ್ ಅನ್ನ ದೇವಸ್ಥಾನನ ಸರ್ಕಾರ ಯಾವ ರೀತಿ ನೋಡ್ಕೊಳ್ಬೇಕು ನೋಡ್ಕೊಳ್ತದೆ, ಬಿಡಿ, ಮುಗಿತದೆ. ಹಾಗೇನಾದ್ರೂ ಆದ್ರೆ ಇವರಿಗೆ ಸರ್ಕಾರಕ್ಕೆ ನಾವು 12/12 1 ಗುಂಟೆ ಜಾಗವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ದಾನವಾಗಿ ಕೊಟ್ಟಿದ್ದೇವೆ ದೇವಸ್ಥಾನದೊಂದಿಗೆ, ಅವ್ರು ಬೇಕಾದ್ರೆ ಹೇಳ್ಕೊಳ್ಳಿ. ಅಥವಾ ಸರ್ಕಾರನೇ ಬಂದು ಈ ಜಾಗ ನಿಮ್ಮದೇ ಇರಲಿ, ನಾವು ಇಲ್ಲಿ ಒಂದು ದೇವಸ್ಥಾನ ಅಂತ ಕಟ್ಟಿಸ್ತೇವೆ, ಅರ್ಚಕರನ್ನ ನಾವೇ ನೇಮಿಸ್ತೇವೆ, ಹಿಂದೂ ಧಾರ್ಮಿಕ ಮತ್ತು ದತ್ತಿ ಕಾಯ್ದೆ ಅಡಿ ಮಾಡಿ. ನೀವು ಹೇಳಿರೋ ಸಮಿತಿ ಯಾವುದಕ್ಕೆ ಬರ್ತದೆ? ಹೋಗುವ ಅಪ್ರೋಚಿನ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಮಾಡಬಹುದೋ ಬೇಡವೋ? ಅವ್ರು ಸಾಯಂಕಾಲ 9 ಗಂಟೆ ಆದ್ಕೊಳ್ಳ ನಾವು ಗೇಟಿಗೆ ಬೀಗ ಹಾಕ್ತೀವಿ, ಬೆಳಗ್ಗೆ 6:15 ತೆಗಿಯಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ನೀವಿದ್ದವರೆಲ್ಲ ಬೆಳಗ್ಗೆ 5 ಗಂಟೆಗೆ ಹೋಗಿ ದೇವ್ರ ದರ್ಶನ ಮಾಡ್ಬೇಕು ಬ್ರಾಹ್ಮಿ ಮುಹೂರ್ತದಲ್ಲಿ ಅಂತ ನೀವು ಹೇಳ್ತೀರಿ. ಅವಾಗ ಆ ಡಿಸ್ಪ್ಯೂಟ್ ಬರ್ತದೆ. ಅವಾಗ ಎದುರ ಬದ್ರ ಕೂತು ಹೌದು ಅದು ಬ್ರಾಹ್ಮಿ ಮುಹೂರ್ತ ಇನ್ನೊಂದು ಮುಹೂರ್ತ ಅಂತ ಹೇಳಿದ್ರು ಕೂಡ ಇಲ್ಲಿ ಒಳಗಡೆ ಎಷ್ಟು ಮನೆಗಳಿದೆ, ಹೊರಗಡೆಯಿಂದ ಎಷ್ಟು ಜನ ಬರ್ತಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾವು ತೆಗೆದಿಟ್ಟರೆ ಒಳಗಿನವರಿಗೆ ಏನು ಅಡ್ಡಿ ಆತಂಕಗಳು ಎದುರಾಗುತ್ತೆ, ಅನಾನುಕೂಲತೆ ಆಗುತ್ತೆ, ಹೊರಗಿನವರಿಗೆ ಏನು ಅನಾನುಕೂಲತೆ ಆಗುತ್ತೆ, ಅದನ್ನ ಅವರು ಪರಸ್ಪರ ಕೂತು ಬಗೆಹರಿಸ್ಕೊಂಡು ಆಯ್ತು ನೀವು ಗೇಟಿಗೆ ಓಪನ್ ಮಾಡೋದನ್ನ ಬೆಳಗ್ಗೆ 7 ಗಂಟೆಗೆ ಓಪನ್ ಮಾಡೋದ್ರ ಬದಲು 6 ಗಂಟೆಗೆ ಓಪನ್ ಮಾಡಿ ಅಂತಲೋ, ಅಥವಾ ನೀವು ಮೇನ್ ಗೇಟಿಗೆ ವೆಹಿಕಲ್ಗೆ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು ಕೂಡ ಒಂದು ಪೆಡೆಸ್ಟ್ರಿಯನ್ಗೆ ಅಂತ ಹೇಳಿ ಪಕ್ಕದಲ್ಲಿ ಇನ್ನೊಂದು ಸಣ್ಣ ಗೇಟ್ ಇಟ್ಟಿರಿ, ಅದರಿಂದ ದೇವಸ್ಥಾನಕ್ಕೆ ಬಂದು ಹೋಗೋರು ನಿರಂತರವಾಗಿ ಬಂದು ಹೋಗ್ಲಿ ಅಂತಲೋ, ಅದನ್ನ ನೀವು ಆ ಸಮಿತಿ ಅನ್ನೋದು ಪರಸ್ಪರ ಮಾತುಕತೆ ಅನ್ನೋದು ಅಲ್ಲಿ ಬರ್ತದೆ. ಯಾವುದೇ ಪ್ರಕಾರದಲ್ಲಿ ನೀವು ಎಲೈಟ್ ಪೀಪಲ್ಲು, ಡಿವೋಟೆಡ್ ಪೀಪಲ್ಲು, ದೇವಾಂಶ ಸಂಭೂತರು ಒಂದು ಕಮಿಟಿ ಒಂದು ಸಮಿತಿ ಅಂತ ಮಾಡಿದ ಕೂಡಲೇ ಅದು ಇನ್ನೊಂದು ವ್ಯಾಜ್ಯಕ್ಕೆ ಕಾರಣ ಆಗುತ್ತೆ. ನಮ್ಮಲ್ಲಿ ನಾವು ಮಾಡಬೇಕಾಗಿರೋದು ಯಾವ್ಯಾವ ಇಂಥ ಅಧಿಪತಿಗಳು ಅಂತ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ, ನಾವು ಅಂತ ಅಧಿಪತಿಗಳ ಕಾರ್ಯಕ್ಷೇತ್ರನ ಸೀಮಿತಗೊಳಿಸಿ, ಅಧಿಪತಿಗಳೇ ನೀವು ಅಲ್ಲಿಯೇ ನೀವು ಹೊರಗಡೆ ಬರಬೇಡಿ ಅಂತ ಮಾಡಿ, ಉಳಿದಂತೆ ನಾವು ಅಧಿಪತಿಗಳ ಆಧಿಪತ್ಯವನ್ನು ನಾವು ಸ್ಥಾಪಿಸುವುದನ್ನು ನಿಲ್ಲಿಸಬೇಕು. ಅದು ಡೆಮೋಕ್ರಸಿ. ಅದು ಡೆಮೋಕ್ರಸಿ. ದುರಂತ ಅಂತ ಹೇಳಿದ್ರೆ ಇತ್ತೀಚಿನ ವರ್ಷಗಳಲ್ಲಿ ಸಂಪೂರ್ಣ ಅದಕ್ಕೆ ತದ್ವಿರುದ್ಧವಾಗಿ ನಡೀತು. ಹಿಂದಿನ ಯಾವುದೇ ನೀವು ಉಲ್ಲೇಖ ನೋಡಿ, ವೇದದ ಉಲ್ಲೇಖ ನೋಡಿ, ಪುರಾಣದ ಉಲ್ಲೇಖ ನೋಡಿ, ಇನ್ನೊಂದೇ ನೋಡಿ. ದೇವಸ್ಥಾನಕ್ಕೆ ಬಾಗಿಲಿದ್ದು ಹೀಗೆ ಬೀಗ ಹಾಕಿತ್ತು, ದೇವಸ್ಥಾನಕ್ಕೆ ಇವನು ಹೋದನೆಂದು ಉಚ್ಚಾಟಿಸಿದರು, ಇದೆಯಾ? ಇಲ್ಲ. ಅದೆಲ್ಲದು ಕೆಲವೇ 100 ವರ್ಷಗಳ ಹಿಂದೆ ಬಂದಿರತಕ್ಕಂತ ಬೆಳೆದಿರ್ತಕ್ಕಂಥ ಘಟನಾವಳಿಗಳು ನಡೆದವು. ನಿಮಗೆ ಯಾವುದೇ ವೇದದಲ್ಲಿ ಕೂಡ ಇಂತಹ ವ್ಯಕ್ತಿ ಹೋದನೆಂದು ದೇವರನ್ನು ಶುಚಿಗೊಳಿಸಲಾಯಿತು, ಇದೆಯಾ? ಇಲ್ಲ. ಪಂಚಗವ್ಯ ಅಥವಾ ಗೋಮೂತ್ರವನ್ನು ಈ ದೇವರಿಗೆ ಸಿಂಪಡಿಸಲಾಯಿತು, ಇವ್ರು ಮಾಡಿದ್ರು ಅಂತ ಇದೆಯಾ? ಇಲ್ಲ. ಒಂದು ಕಡೆ ಬೇಡರ ಕಣ್ಣಪ್ಪನ ಕಥೆನ ನಾವೇ ಓದ್ತೇವೆ. ರಾವಣ ಮಹಾ ಶಿವಭಕ್ತ ದೈವಭಕ್ತ ಅನ್ನೋದನ್ನು ಓದಿ ರಾಕ್ಷಸಿ ಪ್ರವೃತ್ತಿ ಅನ್ನೋನಿಗೂ ಕೂಡ ನಾವು ದೇವಾಂಶದ ಗುಣಗಳನ್ನು ಕೊಟ್ಟು ನಾವು ಪುರಾಣಗಳನ್ನ ಕಥೆಗಳನ್ನ ನೋಡ್ತೇವೆ. ಜೊತೆಗೆ ಈಗ ನಮ್ಮ ದೇವರು ಹೀಗೆ, ನಮ್ಮ ದೇವರಿಗೆ ಇದೇ ನಾಮ ಇರಬೇಕು, ನಮ್ಮ ದೇವರಿಗೆ ಇದೇ ಬಾವುಟ ಇರಬೇಕು, ನಮ್ಮ ದೇವರನ್ನು ರಕ್ಷಿಸೋನು ನಾನೇ ಅನ್ನುವರೆಗೆ ಹೋಗಿ ನಾಳೆ ಬರ್ತದೆ. ಮುನೇಶ್ವರ ಬೇರೆ, ಮುನಿಸ್ವಾಮಿ ಬೇರೆ. ಅವ್ನ್ ಜಡೆ ಮುನೇಶ್ವರ, ಅವ್ನು ಬರೀ ಮುನೇಶ್ವರ. ಅವ್ರದೇ ಗುಂಪು ಬೇರೆ, ನಮ್ದೇ ಗುಂಪು ಬೇರೆ. ನಾವು ಜಡೆ ಮುನೀಶ್ವರನ್ ಕಮಿಟಿಯವರು, ಇವ್ರು ಬರೀ ಮುನೇಶ್ವರನ್ ಕಮಿಟಿಯವರು. ಅದಕ್ಕೆ ನಾವು ವಕೀಲರುಗಳು, ನಾವು ಜಡ್ಜ್ಗಳು ಎಲ್ಲರೂ ಇರ್ತೀವಿ. ಹೌದಾ? ಹಾಕಿಲ್ಲ ಒಂದು ಹೆಬ್ಬೆಟ್ಟು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಣ. Where do our society is heading? What better country, which we call it secular, we are really building? ಕಷ್ಟ. ಇಬ್ಬರಿಗೂ ನನ್ನದು ಮಾತ್ರ ಅನ್ನೋದು ನಿಮ್ಮಲ್ಲಿ ಹೋಗ್ಬೇಕು, ನಾನೇ ಅದನ್ನು ಮಾಡ್ತೇನೆ ಅನ್ನೋದು ಅವರಲ್ಲಿ ಹೋಗ್ಬೇಕು. ಅವಾಗಲೇ ಅವಾಗಲೇ ಮುನೇಶ್ವರ ಸ್ವಾಮಿಗೆ ಏನಾದ್ರು ಸ್ವಲ್ಪ ನೆಮ್ಮದಿ ಇರ್ತಾರೆ. ಇಲ್ಲದೆ ಹೇಳಿದ್ರೆ ಅವನು ಗಣಗಳ ಸಹಿತವಾಗಿ ಅಲ್ಲಿಂದ ಜಾಗ ಬಿಡ್ತಾರೆ. Any other point?
With your kind permission,
Yes.
some issues that were raised.
Yes.
Short reply, then I leave it to my lords. Attend had relied on Karnataka and Hindu religious institutions, charitable endowments.
Is that applicable for temples?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನೇ ಹೇಳಕ್ಕೆ ಮಾಡ್ತಾ ಇರೋದು. ಇಲ್ಲಿ section 220, section 2 subsection 20 definition ಅಲ್ಲಿ ನೋಡಿದ್ರೆ defines what is a notified institution. This act only applies to these notified institutions. If my lords look at section 2 subsection 20. My lords have it.
Yes.
Notified institution means an institution notified under section 23. Before I take my lords to section 23, if I could trouble my lords to look at section 2 subsection 12. Declared institution. Declared institution means an institution declared under section 42. Now, if we could kindly look at section 23. Where it says what is a declared institution? Notified institution, section 23. Madam. My lords have it.
Yes.
Section 23, the state government shall as soon as may be after the commencement of this act publish by notification in respect of each revenue district a list of all charitable institutions, Hindu religious institutions, which on the date of commencement of this act are in the sole charge of the state government, etc., 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 etc. Now, admittedly, the temple in question is not a declared institution. It is not a notified institution under section 23. Now, if we look at the other provision, 42, what is a declared institution?
$45.
42, declared institutions.
Yes.
Declared institutions. The state government may, where it is satisfied on a report of the commissioner under section 43 or otherwise that any Hindu religious institution, whether or not governed by a settled scheme, is being mismanaged, declare such institution to be subject to the regulation of this chapter. So unless there is a declaration under section 42, any Hindu religious institution which is not under the control of the government cannot be taken over by the government. If the defendant had any qualms about the management or mismanagement of the temple by the appellant, then in that case, it's always open to them to file a complaint under 42. Adadmele 43 prakara procedure is there. That is always open to them. That they have not pursued. And they are saying that they are being stopped from offering prayers, etc. Till date, my lord, there are members of the public who go offer prayers. Despite rain, shine, etc., devotees go offer prayers and go back. Next, my lord, if I could take my lords to is section 67 Land Revenue Act. In addition to why it is not applicable as already expounded in section paras 58, 59 and 60 of the judgment I relied on earlier, the 67 hod rehta. My lords have?
Yes.
67. Heading heading in the public roads, etc., and all lands which are not the property of others belong to the government. Similarly, when we look at the body of this, all public roads, streets, lanes, paths,
Except
bridges.
so far as any rights of such persons may be established.
Yes, my lord. Yes, my lord. Deeply obliged, my lord. Which are not the property of individuals or of aggregate of persons legally capable of holding property, and except in so far as any rights of such persons may be established. So in this case, it is my submission that this belongs, it's within 5 acres. I don't think there's anything funny about this, my lord. I may just be permitted to make my submissions.
Use the word funny.
I'm sorry.
Cannot. With all responsibility, he has addressed the argument.
Allah, not senior, my lord. Illinda ಸ್ವಲ್ಪ ನಗು ಬರ್ತಾ ಇದೆ, unnecessary that is.
Yes.
I think it's only fair professional courtesy ಕೊಡ್ಬೇಕು. ನಾನು argue ಮಾಡ್ತಿದ್ದಾಗ
I'm sorry.
ಕೊಟ್ರೆ ಸಾಕು.
We apologize.
Yes, yes, sorry, yes, proceed.
Sorry.
ಇಲ್ಲ ಸರ್, ತಮ್ಮದೇ.
No, his point was that a food corral cannot be under the ownership of any one individual. That is a government property.
That is squarely answered by this honorable court, my lord. It is squarely answered. Food corral can be owned anta. If I could take my lords directly to para 68, para 60, where it specifically deals with 21(2)B, B Karab land.
Which para?
My lord, paragraph 59 in that.
59 ಇಂದ ಅಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿಲ್ಲ ಅವರು ಅದರಲ್ಲಿ ಬರೀ.
I will take my lords. I'll take my lords to it. It goes on till para 69. Adike.
Yes.
Paragraph 60, my lord. 59 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ 67 to 79 consider ಮಾಡೋಣ ಅಂತ. 60 ಅಲ್ಲಿ section 67 of the act, which is similar to section 36 of the code, it basically declares that all lands which are not property of the individual or an aggregate of persons legally capable of holding property would be the properties of the state government wherever it is situated. In essence, the import of section 67 of the act is that every property which is not the property of any individual or a group of individuals would be the property of the government. The provision also clarifies that the declaration would be subject to a situation wherein the rights of certain persons could be established over the lands. To put it simply, 61 Ali, Swami.
Yes.
To put it simply, if a land is not owned by an individual or it is not established that a person has a right over the land, it would be the property of the state. This is on the principle that the sovereign owns all lands within its dominion except those lands which are owned by individuals. Conversely stated, if a land belongs to an individual, the state would not be the owner over that land even under its sovereign powers. This is further discussed, my lord. If my lords could kindly go to page para 66. Where they talk about what is the background behind assessing these lands. Last 66 element, the overarching objective anta ide, ಎರಡನೇ line ಅಲ್ಲಿ. Since from there it is pertinent ಅದಕ್ಕೆ. The overarching objective anta ಇದೆ, my lord.
Para 66.
66 ಅಲ್ಲಿ, ಹೌದು ಸ್ವಾಮಿ.
Yes.
The overarching objective of this assessment is to determine how effectively the landowner can utilize his land to generate revenue, and as a consequence in what proportion the rate of levy could be determined. In this process of determination of the land revenue payable, the provisions recognize that different lands would yield different revenue, and that would be dependent on several facts. However, in certain cases, by reason of the inability of the landowner to use the land for reasons beyond his control, the land is not subjected to an assessment. The principle being that if a person cannot earn any income from a portion of land, he should not be made to suffer the liability to pay land revenue on that portion of the land. It continues, my lord, 68 Ali. It is to be noticed here that if the owner of the land is exempted from assessment of a portion of his land or is exempted from payment of any land revenue, that would not imply that he has lost ownership over that portion. The ownership of that portion of the land would still nevertheless remain with the owner. Merely because the land is not assessed and the landowner is not required to pay any revenue, that would not amount to there being a divesting of ownership of the land in favor of the state. It is for this precise reason, Section 67 of the Act declares and makes it abundantly clear that all lands which do not belong to an individual would be the property of the government. It is to be borne in mind that Section 67 of the Act does not state or declare even indirectly that lands in respect of which revenue is not payable would stand vested with the state government. If I could trouble my lords to kindly look at para 21. Since we are in the judgment, para 21, sir.
Impugn judgment.
How the president have just relied on this particular citation. Squarely where, in fact, in 19, they look at some.
No. Para 21 of Shopa's case.
How this one? Shivappa case. How 20? How
21.
21.
That's a single sentence paragraph.
How Swami? Adu para 20 ali, they have looked at a judgment of this Honorable High Court, division bench of this court anta ide.
Yes.
May I quickly read 20 also, Swami, since it will give context to 21.
Yes.
Division bench of this court in the case of P. Bhimachar versus State of Mysore, reported in 1966 to Mysore Law Journal 184, has stated as follows. It is obvious that the Tahsildar did not correctly understand the expression food kharab. A land is described as kharab land when it is unfit for cultivation. In volume 1 of the Mysore Revenue Manual, the word kharab is explained in that way. The expression food kharab is similar to the expression pot kharab. That is so. Is clear from the Mysore Revenue Survey Manual, where at page 68, the words pot kharab is defined thus. Pot kharab means a piece or pieces of land classed as unarable and included in a survey number. The description has no relevance to ownership. And if survey number 23 belonged to the petitioner as stated by the Tahsildar, that part of it which is described as food kharab is also included in such ownership. Adanna nodi 21 ali independent finding. This decision therefore clearly states that if a survey number belonged to a person, that part of the land which is classified as pot kharab would also be included in his ownership. At 23 allo Swami. 23 allo ಹೇಳ್ತಾರೆ. Thus, even according to this decision, kharab land is capable of ownership, and acquisition of title to kharab land was similar to acquisition of title to cultivable land. By exhibit D1, it is clearly seen that kharab land has also reserved and unreserved kharab land has been acquired for EWHO. Earlier in the day, the court had asked, ಇದು ನೀವು ಏನಾದ್ರು ಪೇಮೆಂಟ್ ಮಾಡಿರೋದು ಏನಾದ್ರು ಪ್ರೂಫ್ ಇದೆಯಾ ಅಂತ.
Yes.
My lords had asked earlier, D1 earlier that you will pay this amount. Is there anything to say that you have paid the amount? I've managed to pull out one document. If my lords permit, I'll hand it over, but it has not been marked in the lower court below.
Subject to the objection of the others.
It's a government document, Swami, settlement.
Should have shown them that a document.
I just looked at it. Idu lunch release. Pertaining to survey number 25, where it clearly mentions temple is also part of the temple torside matte illu. My lord's permit, I'll hand it over. I can also produce it along with an application. I understand that this was not produced before the court below.
For another 20 years, you want to extend it by another 1 decade.
What my lords asked, Aste, Ilandre, I will not, which is why I sought permission of this court.
Unless the opposite party and the applicant they say there no objection to accept the record and to consider the same.
I give it to
deciding the case on merit, the court cannot.
Yes, ma'am. I will give it to my friend. This is what in response to the court's question. Otherwise, I have no intention of producing any additional documents. And hand it over to the court.
That will be considered for deciding this matter. Even though that's not exhibited, can that be?
It is not exhibited.
It is not exhibited. But can the court say consider the said document also along with the exhibits?
Only for vision of the document, it can be looked into. Again, the cross-examination.
Vision of the document would have some influence on the finding, naturally. Otherwise, what is the purpose of vision? The vision of the document requires some observation on the document. Or the inference may have to be drawn based upon that document also.
The whole thing is, if they want to rely upon the document, necessarily it should flow in the form of an application. And in case if the court wants to call for the objection, if there is a valid objection, evidence request.
The procedure is there.
Yes.
Vision that influences the mind of the court.
Yes.
No objection under sentence for the production of the said document, the respondent had no objection.
The only reason I was producing it at this point is to answer the question that my lords had asked. Not otherwise. Specifically to say that how though the temple is part of the 5 acres 36 quintals in survey number 25 anta. In fact, that is also not disputed by them. Written statement allu ide adu. Avaru yavattu helilla ee temple matra nimdalla anta. And my lords had also had asked.
Now, have they not taken a basic contention that that particular portion of the land where the temple is situated was not at all acquired?
They say public temple anta stay. Common area la public land anta. They have not taken the
They have
contention
even
that
say, probably, if I remember correctly, they have even stated that that particular temple with the land beneath it is not the subject matter of acquisition.
no, my
That
lord.
was excluded from acquisition.
No, my lord.
Contention ತಗೊಂಡಿದ್ದೀರೇನ್ರಿ ನೀವು ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
Written statement ಕೊಡಿ. Going back to the basics once again.
My lord, para 7 ಅಲ್ಲಿ written statement para 7 ಅಲ್ಲಿ, I think it's the fourth, it's a very long paragraph, my lord. Just before the 8th paragraph, one 4 line ಇದೆ. 1 gunta of land ಅಂತ ಇದೆ, my lord.
ಓದುವ ಮುಂಚೆ ಇದರ ನೋಡಿ ಅವರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
written statement.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂಡ್ ಆಫ್ ಇದು ಯಾರ್ದಂತಿಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ನೇ ಇರಬೇಕು ಇದು.
ಅವ್ರ written statement ಅಲ್ಲಿ ಸ್ವಾಮಿ. The said contention is
ಡಿಪೆಂಡೆಂಟ್ಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
ಎಷ್ಟೇ ಡಿಪೆಂಡೆಂಟ್ ಹಾಕ್ಲಿಲ್ಲ, ಡಿಪೆಂಡೆಂಟ್ಸ್ ಬಂಡಾರಪ್ಪ ಭಕ್ತಾದಿಗಳ ಸಂಘದ ಪರವಾಗಿ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪೇಜ್ 3 ಸ್ಮಾಲ್ ರೋಮನ್ 2, page 3 small Roman 2. In the process of acquiring several lands for the benefit of the said society ಅಂತ comments ಆಗುತ್ತೆ.
ಹೌದು. The same thing. In this we have said, it's with regard to the 1 gunta. Taking
The
note of
government noticed the existence of Muneshwara temple within the area notified and acquired. More precisely, in an extent of 1 gunta in survey number 25 of Kacharkanahalli village, Muneshwara temple was in existence. Taking note of the same, the government excluded that 1 gunta from acquisition and kept the same for public purpose, treating the said 1 gunta of land as a kharab land and showed the existence of Muneshwara temple therein. That means they have expressly stated it was not the subject matter of acquisition.
My lord, but for this contention, there is nothing that they have produced in evidentiary, in documentary evidence to show that this 1 gunta was not handed over. I have, on the other hand, demonstrated before
This argument is fine. Otherwise, your first submission that say they have never taken a contention.
But for this, there is no documentary evidence. I stand corrected. They have made a bare denial. There is no, and in fact, the bare denial ge matte, unfortunately, I can't produce this document where it clearly shows. In fact, there is a sketch, my lord, that we have also marked as a document. Exhibit the site plan which has been granted, which clearly shows P39 ali Swami.
Could you please explain? ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ ಸ್ಟಾಕ್ ಅನ್ನು ಟ್ಯಾಗ್ ಹಾಕಿದೀನಿ. ಪೇಜ್ ಬಿಚ್ತಾ ಇದೆ.
39.
P39.
There's one sketch. Original document. CR ಒಂದು sketch ಇದೆ. ಯಾವ document ಅಂತ ನೋಡಿದ್ರೆ.
Exhibit P39, index it is shown as a site plan in the annexure to the judgment.
Yes, ma'am.
They say that it is not there in the trial court record. Exhibit P39.
There is one plan produced, my lord. Unfortunately, I
Paper book ಅಲ್ಲಿ exhibit P39 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
paper book ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ನಾವು ಅಪ್ಲೈ ಮಾಡಿದಾಗ ಇಲ್ಲ ಈ original
ಕೊಡಿ ಒರಿಜಿನಲ್ ಕೊಡಿ ಅವರಿಗೆ ಒಂದು ನಿಮಿಷ.
site plan.
Exhibits documents original ನೋಡ್ಲಿ ಇಬ್ರು ನೋಡಿ.
29 is what that was marked, my lord. That it clearly mentioned that the temple is there with the sanction plan that was there.
ನೋಡಿ ಯಾವ್ದಾದ್ರು ಎಕ್ಸಿಬಿಟ್ P39 ಬಂದೇ ಇಲ್ಲ ಅಂತಿದ್ದಾರೆ, ಇದು ಪಾರ್ಟಿನಲ್ಲಿ ಇಲ್ಲ ಅಂತ.
It's paper to prepare ಮಾಡಿದ್ರೆ apply ಮಾಡಿದ್ರೆ ಇದೆ.
Then how to proceed when you say that a particular exhibit is there to your aid?
Yes, my lord.
That exhibit is not there in the records.
But I'll proceed without that document, my lord, where my submissions made so far may be taken note of. I have established, in fact, one of the grounds I've taken in my appeal is that my ownership is not proved anta heli, adike possession illa anta heli, they have dismissed my suit, the court below. It is my endeavor that exhibit D1, including my possession certificate, my sale deed, and that I produced before this honorable court, that I produced as exhibits there, clearly states, it is admitted that there was kharab land, it is admitted that the entire kharab land was handed over. Aur heltare aur idralli one kharab one gunta kharab land kottilla anta, but there is no documentary evidence to the contrary to support their, they have produced no documentary evidence. I have on the other hand pointed out clearly from their own document, aur produce madidare award adral torsidini nanu that this was for the entire land. Then there is unreserved kharab land, then there is reserved kharab land. Reserved kharab land was at 0.01 gunta where the temple is, and it says public use anta. And I also relied on one Madhya Pradesh High Court judgment where it says that even if there is a temple, public temple on private property, that will also be under the ownership of the private land owner. If my lords could just take that judgment.
ಅದು ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು day 1 ನಲ್ಲಿ.
ಹೌದು ಸ್ವಾಮಿ, ಅದೇ
Can answer that point. Yes.
Where if I may just be permitted to read paragraph 56 of that judgment.
That comes to you reopening your main argument.
Just ಇವಾಗ ಬಂದಿದ್ದಕ್ಕೆ ರಿಪ್ಲೈ ಇಲ್ಲಿ just that one line ಅಷ್ಟೇ, paragraph ಓದ್ತಾ ಇಲ್ಲ. Paragraph 56 ಅಲ್ಲಿ ಒಂದು ಲೈನ್ ಇದೆ. Defendants pleaded that it is a public temple and they stopped then and there only. If public offers puja and comes for darshan of deities, then also nature of property does not alter and it remains private property. On this count also case of dependence pales into insignificance and oblivion. Para 56 of this Madhya Pradesh High Court judgment dated 22/4/2022. But for the blanket statement of the respondents that I have prevented them from offering puja, there is nothing else to show. They have not buttressed their argument. Whereas on the other hand, I have produced exhibits that I marked, police complaints that I filed from exhibits P16 to P23, which shows what is the nature of their interference. ಯಾವಾಗಾದ್ರೆ ಅವಾಗ ಬಂದು ಇಲ್ಲ ಹುಂಡಿ ಹಾಕ್ತಿವಿ, ಇಲ್ಲ ಬಿಲ್ಡಿಂಗ್ ಇದ್ ಮಾಡ್ತೀವಿ, ದೇವ್ರನ್ನ ಬೇರೆ ಕಡೆ ಕೂರಿಸಿ ನಿಮ್ ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ, meanwhile we'll renovate this temple, ಆಮೇಲೆ ನಾವು ಮತ್ತೆ ವಾಪಸ್ ಹಾಕ್ತಿವಿ. So all this at P16 to P23, where my lords posed this question, interference ಎಲ್ಲಿ ತೋರಿಸಿದೀರಾ ಅಂತ. P16 to P23 I have marked, I have shown the interference. What is the exact nature of interference? I'll conclude by reiterating, ಯಾರು ಬೇಕಾದ್ರೂ ಬಂದು they can offer worship. That has never been stopped and we will not continue to stop it at any point in time. But when you try and interfere with the running of the temple in terms of hundi haktini, building construct ಮಾಡ್ತೀನಿ, ಬೀಳ್ತಾ ಇದೆ, these are all unsubstantiated statements that have been made before this court, either in evidence before the trial court. They haven't shown anything to show that illa building is in a dilapidated condition, it is going to break down, fall, etc. We have ensured it is maintained as best as it could be and public can still offer prayers even as on today. Ashte sir.
From both sides, what is the argument of Leonard? What is for the respondent? Other. The counsel for the respondent, while concluding this argument, clearly categorically stated that The respondents want only right to worship Muneshwara, the property under dispute, and nothing more. Respondents are not bothered, or the respondents are not about the alleged ownership. The ownership, full point. Similarly, the learned counsel for the plaintiff, in her conclusion sentence, in her reply argument also, reiterated the very first statement what she had submitted to the court while opening her argument on the main appeal, that the plaintiffs have never prevented any persons visiting the temple and worshipping God Muneshwara. They are not prevented pay their respect to Muneshwara by visiting the temple. Since the present defendants in the guise of worshipping have attempted to put up construction, altering the structure, it was necessitated for plaintiff to institute this. Next line. The above statements made in the argument has been recorded in the presence of and to the knowledge of learned counsels from both sides, and without affecting the meaning, spirit, and intent of the statement made by them. Sir, yeah.
Whole argument which has been made by the other side is as if it is a declaratory suit. In a simple suit for injunction, they should show their possession and title. That has not been established. I mean, the public use Allah Namde and Hedda. Even the award which is on record shows at page number 340, it is a public use only, it has been left to public use. It has been left to public use.
Judgment reserved.
Please.
Deeply obliged for a very patient hearing over the last 4-5 days, despite several impassioned arguments from both our sides.
Yes. Now the next.
Obliged.
Further arguments? 230 matter. Till number 46, Sri KV Narasimhan, Prashant HS, correspondent.
For the appellate.
Except serial 40, the other matters may not reach today. Their counsels in other matters need not wait. Yes.
Serial number 40 may not reach today. Come. I will take it also.
Yes, you need not wait. It may not reach today.
We can take next week or again.
Week after next.
Please.
Yes.
Yes. On the previous occasion, my lord, I had made 4 primary contentions. One is, my lord, the misjoinder of cause of action, and hence the suit is bad for multifarious. This was first submission. The second submission was that the alleged suit agreement to sell being unregistered document, it cannot be pressed into service for any claim of possession. Third, my lord, the suit being barred by limitation. Fourth being, it is hit by delay and laches. And the fifth that I was canvassing before my lord is regarding Exhibit B36, which is the alleged shara, under which the conditions of the original agreement has been varied, and also to content that the persons who are named as the executants therein are not the persons whose signatures are forthcoming in the first 2 pages, and also that the LDM of defendant number 14 could not have found its place in view of the fact that she was dead as on that day. At that juncture, my lord, since the questions had been formulated by my lord, I would, subject to the what my learned friend would say and reserving my contention to reply it. My respectful submission, my lord, in a very brief and a nutshell on the questions that have been framed by my lordship is this: that a shara, which my lord is ultimately an endorsement, cannot be independent of the original agreement itself.
The first question.
The first question, my lord. Yes, my lord. As far as the first question is concerned, I respectfully submit that it cannot be. That a single shara would not be a valid one.
It is between the agreements or between the same parties.
Yes, my lord, please.
If it were to be between the same parties, then how come?
My respectful submission is, my lord, a shara, by the very meaning that it conveys, is only at best an endorsement or an acknowledgement of a particular amount being paid or so. It is an endorsement. Literal meaning of shara being. And hence, a shara in itself is not an agreement.
It's a bit B36.
Yes. My lord, page number 1 of that exhibit B36, my lord, it is titled Shara. It says, Dinanka 28/2012 ಕ್ರಯದ ಕರಾರಿನ ಮುಂದುವರೆದ ಈ ಕರಾರು ಈ ದಿನ ಅಂದರೆ ಸನ್ 2013ನೇ ಇಸ್ವಿ ಜೂನ್ ಮಾಹೆ ತಾರೀಕು 10ರಂದು ಅಂತ ಬರೀತಾರೆ. So the title is Shara, but the way my lord it begins is as if it is a continued agreement. My respectful submission at the outset is both are two different pieces of documents altogether. It cannot have the same bearing because having regard to the characters each one of would have.
Can't that document be appraised,
Please,
and analyzed,
yes,
ignoring the title given to this?
My lord, absolutely, my lord. I do not have any difficulty there. Then, my lord, it must stand the all the characters, qualities and nature of a valid agreement is what it must have. It can't be short of it. It should be an agreement in itself, where, my lord, the original one is continued. And it must satisfy the ingredients of a validly constituted contract as the Indian contract requires it to be.
Yes.
My lord, as could be seen there, my lord, there are 3 vendors who have been specifically named. Doddamanni, Lingaraja Aras and Basavaraja Manni. On the other hand, if the original agreements are seen, my lord, we have a batch, my lord, where defendant number 1 to 12 are the signatories of one of the agreement, defendant number 13 to 18, and defendant number 19 to 22. Now that's how, my lord, 3 agreements have been made. Now this, my lord, allegedly is in a form of a single document.
All the 33 parties should have been here.
They should have been shown as the vendors, and they should have signed the alleged agreement or a shara. Now, even, my lord, they are even not named as the vendors. My lord, the first name that is mentioned, my lord, as the vendor number 1 by name Doddamanni. Her signature is not forthcoming in the first and the second page of Exhibit P36 at all, though she has been termed as a vendor number 1.
What was her rank as defendant?
My lord, she is defendant number 1.
Is there an admitted signature in the agreement for sale?
My lord, yes, the agreement is Exhibit P34 pertains to them, and she, my lord, affixes her LTM. P34 is the agreement concerning them.
P34.
Please, my lord. Serial number 1, my lord, is her right.
Then
Please. The second person, my lord, is Lingaraja Aras. He is defendant number 19 in this suit.
she is vendor number 2.
Please, my lord, he is vendor number 2.
In the suit, defendant number 19.
19, my lord, please. Exhibit P1 is the agreement concerning him, my lord.
Yes.
Of course, this signature, Radhit signature, is available in all the 3 pages of this Exhibit P36. Assigned as K.M. Lingarajas. I think it's K. Lingarajas there.
Yes.
My lord, the third vendor, my lord, who has been mentioned there, is this Basavarajamanni. The Basavarajamanni, wife of late Mallaraja Aras.
Yes.
My lord, she is not a party to exhibit P35 agreement. Her signature is not forthcoming in the entire exhibit P36.
It was not a party to any of three agreements.
Please.
Exhibit P1, P34, P35.
Yes. Even to P36. Her signature, my lord, is not. Of course, though she has been shown as vendor number 3.
It was not even signed in P36.
No, not in P36 also. So my respectful submission is, my lord, a person who is not a party to the original agreement itself, to be called as vendor, one of the vendor for the first time in an alleged shara or a continued agreement, then even her signatures not being there. Then, my lord, such an agreement or a shara, my lord, has absolutely no consequence in the eye of law.
Yes.
So, my lord, as far as the first question my lord has formulated, my lord, my respectful submission is, since we have got three set of different persons owning three distinct properties, having entered into three different agreements, then, my lord, if there need to be any endorsement regarding any receipt of an alleged amount, then, my lord, that has to be endorsed on that agreement, or a separate shara could have been drawn. But it can't come in this fashion. And a single document, my lord, purportedly extending the period for performance of the contractual obligation infinitely, sets up a variation as far as the original terms of the agreement is concerned.
What is your answer to the question number 2?
My lord, as far as question number 2 is concerned, my lord. Now, please see, my lord, the way in which exhibit P36 itself is drawn. Now, first 2 pages, none of these signatures or LTMs will be forthcoming. And only in page number 3, my lord, this has come up. And it has absolutely nothing which has been mentioned there. The alleged fact of amount being tendered and it being received is something, my lord, that is not forthcoming in page number 3 of the exhibit P36 at all. This is drawn on a white paper. And there is
in white paper because it is page 3.
That's right. That's right.
According to them, page 1, 2, 3 are the part of the single document.
Please, my lord.
It is their contention.
Please, my lord. Now, and hence, my lord, if at all it is their contention that it was a shara, where an endorsement has been made by the parties to the effect that they have accepted a particular amount of money, then, my lord, that endorsement invariably will have to carry their signatures because that is the way they express their consent for taking the alleged amount. Now, that, my lord, being absent regarding in relation to the first 2 pages where it actually makes a reference to, my lord, these LTMs or signature that has been taken only on the page number 3 not hold any water.
So whether any documents like this require the signature of the executants of the documents on each page?
My lord, now the case made out is, my lord, that we have endorsed. We have endorsed the acceptance of a particular amount. And on the virtue of which, my lord, this extension being made, the premise is that the suit is well within the law of limitation. Now, once this is being invoked, my lord, for the purpose of section 18 or 19 of the Limitation Act, my lord, my acknowledgement of this varied terms, my lord, becomes extremely necessary. Now, each one of them, my lord, must invariably agree to it. Now, there are only 3 vendors out of which 2 do not sign in the first 2 pages. And then, my lord, the rest of these persons, my lord, only on the last page if the signature is being taken. Now, my lord, a positive evidence also would have to be shown that it is in this fashion that an endorsement had been taken and the consent had been obtained by each of them. And it was in recognition of this fact that they have affixed their signature or LTM on the alleged shara or the continued agreement.
Yes.
My lord, on the other hand, if this were to be considered as a continuation agreement, my lord, then the necessary ingredients of there being a promisor, then there being a promisee, then, my lord, a consideration flowing it, then it forming a concluded agreement, and enforceability of it to mature into a contract must be forthcoming. Now, as long as certain persons never be the promisors, then, my lord, this would not even mature into an agreement, much less a contract which is enforceable. And hence, my lord, taken it as a, we need to make it, my respectful submission is I need to make a distinction as to whether it's a shara or an agreement. Now, if it's only a shara, then, my lord, the third question my lord has raised, my lord, can never alter the terms of the original agreement. because section 62 of the Indian Contract Act requires a contract to supersede an earlier one, where the terms would be varied or altered. Now, it can't happen in the form of a shara. It has to happen invariably from another agreement which is enforceable under law. Now, an agreement invariably will have to have a promisor.
Want an endorsement
Please, my lord.
by the parties to the agreement
Please, my lord.
cannot extend the time for performance of the contract.
My lord, only for the purpose of section 19 of the Limitation Act, my lord, it will have an effect. That's all. Now, it is also called out in section 19 of the Limitation Act that it will create a fresh period for limitation. That's what it only says. So the limitation starts renewing.
Yes.
Stands renewed.
Yes.
Now, but now, my lord, now when the contractual obligation is set that within 6 months this have to be performed, and then this is the amount that is agreed to be paid. Now, my lord, a variance is set by the virtue of which we need not go by the law of limitation or the 6 months time that have been prescribed, but at our infinite time on a totally contingent happening of an event where all documents are kept ready. And such an infinite extension of a time is invariably, my lord, setting a variance into the terms of the contract, because ultimately, my lord, time would also be an important essence of the agreement.
Can the parties to an agreement,
Please.
maybe by shara, calling it as a shara, or continued agreement, whatever name be, making an endorsement, take away the time period fixed therein?
My respectful submission is, my lord, they can do it. And when they do it, now when they do it, my lord, it must have the characteristic of a duly constituted agreement. Now that shara must mature itself into an agreement, having all the bearings of an agreement. That's where I say all the promises must necessarily be there. They endorse and they say that I am extending this limitation for an unspecified limit of time or till the happening of a particular event. They must all come forward and they must execute such a document by the virtue
Just
of
now
which
in the previous sentence, you said that they can extend the time by way of endorsement regarding performance of the contract.
Well, that endorsement would have to be read down as a continued agreement or an agreement in itself. A mere endorsement.
An agreement says within 6 months you should do it.
Please,
at the end of 6th month, the parties to the agreement, they make a shara below that. The time for the performance of the contract is extended by another 6 months from today.
Please,
they sign it. They show it as a shara or endorsement.
Please, ma'am.
And they write it. Won't it extend the limitation?
It certainly does. It certainly does.
Is it not a variation in the strict sense as you are now attempting to interpret?
Well, but my respectful submission is there was an agreement between both the parties to the extent that there shall be an extension of the limitation. That's when, my lord, even the nomenclature becomes insignificant and the variation, my lord, would be nevertheless considered.
Then what is lacking here?
My lord, there is no promisor at all as far as this document is concerned. The consent, my lord, is conspicuously absent. This is the relevant page. Page number 2 is the relevant page. It can't go in this fashion, by the virtue of which there will be only 3 signatories, out of which 2 are not even named as the vendors. Extending the time infinitely concerning 3 different agreements, concerning 3 different properties. And hence, my lord, my respectful submission is shara per se cannot alter the nature, alter the terms of the original agreement. It only endorses the receipt of a particular thing. But they do something else more than that, then it must have a characteristic of an agreement. And since there is no format that has been prescribed for an agreement, there are a number of occasions, my lord, when the mutual statements that have been made or even the oral proposal being given and it being accepted, all have been deemed as agreements by itself.
Yes.
As far as question number 3 and 4 is concerned, cumulatively I can answer. A shara will not have the capability per se to either vary the terms of the original agreement or to create a contingent situation. Because it's a mere endorsement of the receipt of a particular amount.
Yes.
Now, my lord, as far as the para 3, page number 3 is concerned, my lord, as far as question number 5 is concerned, that is, my lord, one of the observation my lord was pleased to make is the schedule, absolutely there is no clarity or description of those properties. It's only a mentioning of it. And I pointed out, my lord, in the third column of the signatures, serial number 4, LTM of Nanjamani, my lord, is forthcoming. That is one of the crucial contentions that were taken in the written statement.
She was dead.
She was dead as on the day. And D15 Nagaratnamani's LTM or signature, my lord, is not at all forthcoming. She has put LTM in the original agreement.
Defendant 15.
Defendant number 15.
She is Nanjamani. Nagamani.
Nagaratnamani is defendant number 15. Please. Her LTM is forthcoming in exhibit P35.
Yes.
In page number 4, my lord, the witnesses, my lord, would sign. Only peculiar, my lord, is my respectful submission.
What peculiarity?
My lord, generally, my lord, the Biklam is always, my lord, written immediately after these signatures are made. Now, that's where I said it was a white sheet of paper. Now, certain signatures and LTMs are there. And thereafter, my lord, when we overturn the leaf of the page, then alone, my lord, these signatures of the witnesses are forthcoming. Not saying it's illegal, but I'm saying that this is not the way generally a duly constituted agreement or shara would be drawn. You'd be more than diligent enough to ensure that the biklam is in its right place. So my respectful submission, my lord, is if at all it is read only as a shara, then all this extension, the variation of the rights would never arise. And it has to be, the terms cannot be considered. But if it has to be read as an agreement, then since promissor's consent is not evident by they affixing their signature, it falls short of an agreement per se, and then there cannot be a variation even in that event. In any event, exhibit P36 stands vitiated by forgery.
You completed your argument.
Now I need to go to the important aspect of the agreements itself, the way in which the oral evidences come in led.
Are you on point number 4 still or point number?
My lord,
Point number 5 you can ask.
Yes, my lord.
Exhibit P36 is forced.
Please, my lord. I have two submissions, my lord, one regarding the agreements itself. Lastly, my lord, as far as whether equitable considerations would warrant decreeing of the suit for specific performance. These are the 2 points, my lord, that I need to canvass.
Learned counsel from both sides present had the further argument of in part. Since the court time is over, list this matter on the date put.
Shall I have it as next week?
Anyway, it is started next week.
Next week. Or if you are aware whether I continue here in Bangalore, then I can give date. I am not sure right now.
It will be on Friday, my lord, if subject to my lord's convenience.
No, I am available since
The reason is the
morning 10:30 to evening.
like the other postings are.
But I do not know where I would be put in the next week. Because the roster would be coming to an end by this weekend. I do not know where I will be placed and with what subjects I will be given to. I will just have it as next week.
Please.
As a part-head matter.
As a part-head matter.
Please.
It is matter in the next week on the top of the list.
Okay.
I have not given specific time as 2:30.
Yes, please.
Last time it was given.
Please.
When as 2:30 no, it's convenient. Complete another backup by 2:30.
2:13 ಹಾಕೊಂಡಿದ್ದು ನೋಡುವ.
Number 41.
Further hearing, still number 40, Sri A. Krishnaswamy, Lokesh BG for R1 to R4.
Like password ಆಗಿದೆಯಾ? Password. Card again, none appear. Hence the matter could not be proceeded today. ಇಲ್ಲಿ ಮೇಲೆ ಸಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟಿದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಸೋ ಇಂದೋರ್ ಮತ್ತೆ ರೋಸ್ಟರ್